All right, everyone, you need to make sure your phones are on silent. The way the day is going to go today is we're going to start with closing arguments, and there's nothing worse when you're in the middle of your closing argument and a phone goes off. Diana, I'm going to do my best not to veer off my diet. But since Norma just sent that message, she said the McRib is back. I'm going to try not to. The McRib is my weakness, even though people say it's not real meat. I don't know if it's the special. There's something about the sauce. Is it like the movie with Charlton Heston when they say, it's the people? But at least it's not green. Hello, George.
Morning, Your Honor.
Good morning. The state had asked for 15 minutes. Are you all okay with 15 minutes, or did you need more than 15 minutes?
That's fine by me. Let me see what Adam wants.
All right. And Deputy, did you make sure Mr. Dixon is brought up? All right, can you bring him out? Yes, we're ready. All right, we're just waiting for them to bring him out and waiting for
Yeah, Adam advised me there's some real bad traffic going on, so.
Okay. All right, while we're waiting for Adam, then I am going to call the docket. When I call your name, let me know that you're here. Damon Thomas is in custody. Christopher Robles, custody. Alexander Castro. Alexander Castro. John Albert Garcia, custody. Andrew Arnett. Andrew Arnett. Deputy McKee, I'm going to give everybody till 10:30 today because I'm not sure if Lance called them and said we were starting at 10. John Albert Sanchez.
Present, Your Honor.
Thank you. Anthony White. Anthony White. Josh Shanae Caldwell. Thank you. Vicente Navarrete. Thank you. And custody is Joe Perez. Lisa Marie Anderson. And custody is Jose Carrion. Joel Singleton. I'm sorry, Sinston. Mari Amanda Fuller. Thank you. Isaiah's, I know I'm mispronouncing that.
Yeah, no.
Thank you. I'm going to work on that. There's a lot of vowels going on. I have to figure out what to do with them. All right. Christopher Robles is in custody. Jose Casa de Mata. Thank you. Deputy Mejia is never helpful with me with the pronunciations. Terrence Bowie. Terrence Bowie. Larry Nunez is in custody. Heather Martinez. Heather Martinez. Kimberly Dixon is in custody. Christopher Jones. Custody. Jaro Rivera.
Here.
Jasmine Hunt. Robert Lopez. Tanya Ortega. Custody. Mark Costa.
He's present with counsel, Judge.
All right, thank you. Joseph Harris and Vernon King is here. And Katsakote Martinez is in custody. All right, is there anyone present whose name was not called or you came in late? All right, we're going to start over here. Batman. I'm sorry, what? All right, do you know who your attorney is?
No.
All right, just give us do you know your SID number?
Yes.
Okay, what is your SID number?
SID number is 1187447.
All right, thank you. Who else over here? Yes. Do you know who your attorney is? Or do you know your SID number? All right, just give it. Have you met your attorney before? All right, just give us a moment. Over here? Joey, what? Do you know your case number, SID number?
1179950.
All right, thank you. Yes. Castro, what? Do you know your case number, SID number?
855223 for the SID.
All right. So anyone else coming in late?
Terrence Bowie, Your Honor.
All right, thank you.
Thank you.
Deputy, does he need to be in custody? Yes. All right, Mr. Bowie, if you'll come forward, please.
Yeah.
All right, so the four people who, if you haven't had contact with your attorney, we're gonna make sure that you have contact with your attorney, okay? Is there anyone else? All right, so this is the way the morning is gonna go. It's gonna be a little chaotic, but sometimes chaos is great. We are waiting for the defense attorney to appear. And once the defense attorney appears, we're going to do closing arguments before the jury. So everyone, please make sure your cell phones are off or on silent, because there's nothing worse when you're in your groove doing your closing argument and somebody's cell phone goes off. So let's be kind to the attorneys and not have our cell phone on. Once the state brings down their boxes, you all will be able to confer. So right now you'll notice family violence is not here. The reason why they're not here is because we're supposed to start at 10 with our docket. So if you all would like to go downstairs, stroll in the cafeteria, you're more than welcome to do so, but you need to be back here at 10 because we are recessing at noon. And depending on what happens with this jury, we may end up starting punishment. And if we start punishment, we will take you over a break. We will not reset you because we are in trial. Today is Tuesday. It's going to be a great day. The reason why it's going to be a great day, because it's not Monday, it's Tuesday. So we have something to be thankful for. And we're closer to Friday than we were yesterday. So that's where we are on this docket. Attorney's not available to confer yet. So please enjoy. And I will call, you want me to call them up for you? Okay, thank you so much. And if they haven't spoken to their attorney, I'd like for them to see if we can get the attorney here so the attorney can speak.
Stuck in traffic.
All right, thank you so much.
Good morning, Judge.
Good morning. Yes,
Mr.
Bowie.
Mr. Bowie, you know he had those cases that he has in the process. And can they take down the satellite and register this there?
Oh, they're short. So,
Would you be able to magistrate?
yeah, I can magistrate him.
At the bond?
The bond setting is going to be a little bit difficult, but I tell you what, if you will wait until they finish their closing arguments, I'll be able to do that at that time.
Great.
Okay,
Thank you.
you're welcome. George, you have an idea of his ETA?
Let me try to call him. He's here, Judge.
Oh, awesome.
Just come in and have a seat. Morning, Your Honor. My apologies. Traffic was terrible.
Oh, no, no problem.
And then there was-
So Adam, are you okay with 15 minutes? Or do you want more?
something y'all looking for. I'm thinking 20, Judge.
Okay,
What do you think? 20, I feel better with 20, Your Honor.
all right. Does anybody want a time announcement or warning?
Judge, you just give me like 5 minutes.
Okay, 5 minutes.
Same with us, Judge. 5. We may not use.
Okay. All right, well, the jurors here. Is there anything you all need before we call the case?
Anything? No, Your Honor. Nothing I can think of.
Okay. Yeah, if you can line them up. All right, everyone. Need silence.
Jason.
And I know no one would do it, but there's not to be any outbursts during the closing arguments. Sometimes people may say stuff that you don't like, but there's not to be any outbursts during the closing arguments. Court is calling 2022 CR 9807, State of Texas versus Vernon Dixon. Can I have parties announced for the record for the state?
Jason Garahan and Danielle Escobar for the state, Your Honor.
Adam LaHood and George Schaefer for the defendant.
And are you Mr. Dixon?
Yes, ma'am.
Have both parties had a chance to review the charge of the court or the jury charge?
Yes, Your Honor.
We have, Your Honor.
Any objections?
From the state, Your Honor.
None from the defense, Your Honor.
All right, well, Deputy Mejia is lining the jurors up and we will start.
Yeah.
Okay.
We're ready.
All right.
All right, everyone, please be seated. All right, you all know that the courtroom is slightly crowded. That's part of my docket today, but it has nothing to do with this trial. Does everyone understand? All right, I'm going to read to you what's called the jury charge, a charge of the court. You do not have to memorize it because you will be given it once you go back to the jury room. Members of the jury, the defendant, Vernon Dixon, stands charged in count 1 of the indictment with the offense of murder alleged to have been committed on or about the 31st day of March 2022 in Bexar County, Texas. The defendant, Vernon Dixon, stands charged in count 2 of the indictment with the offense of unlawful possession of a firearm alleged to have been committed on or about the 31st day of March 2022 in Bexar County, Texas. The defendant, Vernon Dixon, stands charged in count 3 of the indictment with the offense of tampering with physical evidence alleged to have been committed on or about the 31st day of March 2022 in Bexar County, Texas. 1. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. 2. Our law provides that a person who has been convicted of a felony commits the offense of unlawful possession of a firearm if he possesses a firearm after the 5th anniversary of the person's release from confinement following conviction of the felony, or the person's release from supervision under community supervision, parole, or mandatory supervision, whichever date is later, at any location other than the premises at which the person lives. The offense of possession of cocaine under 28 grams is a felony offense. 3, a person commits the offense of tampering with physical evidence if, knowing that an offense has been committed, the person conceals a thing with intent to impair its verity, legibility, or availability as evidence in any subsequent investigation of or official proceeding related to the offense. The offense of aggravated assault with a deadly weapon is committed if a person intentionally or knowingly causes bodily injury to another while using or exhibiting a deadly weapon, or if a person intentionally or knowingly causes serious bodily injury to another. 4, individual means a human being who is alive. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Possess or possession means the actual care, custody, control, or management of property. A deadly weapon means a firearm or anything that in its use or intended use is capable of causing death or serious bodily injury. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. 5, a person acts intentionally or with intent with respect to the nature of his conduct or to the result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 6, with respect to the evidence admitted in this case concerning the defendant having been previously convicted of a felony, if he was, you are instructed that such evidence cannot be considered by you as in any manner proving or tending to prove that the defendant was in possession of a firearm on or about the 31st day of March 2022. 7, count 1, murder. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 31st day of March 2022 in Bexar County, Texas, the defendant, Vernon Dixon, did intentionally or knowingly cause the death of an individual, namely Avante Boyce, by shooting Avante Boyce with a deadly weapon, namely a firearm, or the defendant, Vernon Dixon, with intent to cause serious bodily injury to an individual, namely Avante Boyce, did commit an act clearly dangerous to human life that caused the death of Avante Boyce by shooting Avante Boyce with a deadly weapon, namely a firearm, then you will find the defendant, Vernon Dixon, guilty of the offense of murder as charged in count 1 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Vernon Dixon, not guilty of count 1. Count 2, unlawful possession of a firearm. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 31st day of March 2022 in Bexar County, Texas, the defendant, Vernon Dixon, having been convicted of the felony offense of possession of cocaine under 28 grams on the 20th day of July, 1992, and cause number 1991 CR 0678 in the 187th District Court of Bexar County, Texas, did intentionally or knowingly possess a firearm after the 5th anniversary of Vernon Dixon's release from confinement or release from supervision under community supervision, parole, or mandatory supervision following conviction of said felony at a location other than the premises at which Vernon Dixon lived, to wit, a public place, then you will find the defendant, Vernon Dixon, guilty of the offense of unlawful possession of a firearm as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Vernon Dixon, not guilty of count 2. 9, count 3, tampering with physical evidence. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 31st day of March 2022 in Bexar County, Texas, the defendant, Vernon Dixon, knowing that an offense had been committed, to wit, aggravated assault with a deadly weapon, did intentionally or knowingly conceal a thing, to wit, a firearm, with intent to impair its verity, legibility, or availability as evidence in any subsequent investigation or official proceeding related to the offense, then you will find the defendant, Vernon Dixon, guilty of the offense of tampering with physical evidence as charged in count 3 of the indictment. If you do not so find, or if you have a reasonable doubt thereof, you will find the defendant, Vernon Dixon, not guilty of count 3. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You're instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet, chat room, blog, or website to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You're instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror was certified thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous verdict. If that can be done without violence to the individual judgment, a unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to this case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and jury forms are attached. State, are you prepared to proceed?
Yes, Your Honor. I very briefly wanted to cover a few things that are found in the jury charge. You're going to hear from the defense, and then you're going to hear from Jason one last time before we're done. So, as the judge mentioned, there are 3 counts of this case: murder, unlawful possession, and tampering with physical evidence. Now, each of these are independent of one another. So you have to consider, did the state prove the elements in each count independent of one another beyond a reasonable doubt? So let's start with count 1, murder, separated into 2 paragraphs. Now, what that means is that it's paragraph A and paragraph B. One juror could say that they found beyond a reasonable doubt paragraph A, and then the rest can all say paragraph B. It's just that it's unanimous that it's one or the other. So let's start with paragraph A. It's on or about March 31st of 2022, Vernon Dixon in Bexar County, Texas, intentionally caused the death of Avante Boyce by shooting him with a firearm. Now, there have been many witnesses who have come forward and said that those events happened. They've explained that through their testimony. And again, it's each individual part. It's the date, where, who, shooting, intentionally causing death by shooting a firearm, which is a deadly weapon. That's what everyone agreed on. So paragraph B, it's again, on or about March 31st of 2022, the defendant Vernon Dixon, with intent to cause serious bodily injury to Avante Boyce, committed an act that was clearly dangerous to human life, shooting a firearm at Avante that caused his death. Now again, it's not that he intended to kill, it's that he intended to cause serious bodily injury. How do we know that? He shot at him with a gun. You are intending to cause serious bodily injury when you do that. And it's clearly dangerous to human life because you can't say what that bullet's going to do to a body once it hits. So then moving on to count 2, it's unlawful possession of a firearm. So the defense in States 39 stipulated that the defendant was convicted in, it was 1992 CR 0678. So that's already been stipulated to, that he was convicted. Now it's looking at, did he possess a firearm? Many witnesses came and said he was the one who had the gun. Next, was it in a public place? Well, he didn't live at that apartment complex. He had access to it. Several people had access to that apartment complex and that patio area. So it was a public place. Then the next one, it's count 3. It's tampering with physical evidence. Now, a witness came and said, it was Donald Neely. He said that after the shooting, Vernon handed him the firearm. And that's why the firearm wasn't found. He handed it off with the intent so that it couldn't be found. When you hand it off to someone, you're not saying get rid of it. Now, again, each of these are independent of one another. It's, did the state prove each count beyond a reasonable doubt? Now, you aren't going to get any of the police reports that have been referenced to by several of the witnesses. That's not going back there. You can't let bias or sympathy play a role in your determination today. The question you have to answer is, for each count, did the state prove these elements beyond a reasonable doubt? We have. We brought many witnesses to say what happened that day and how Avante lost his life. We have proven on each count that he is guilty. Thank you. And state reserves all the time. Thank you.
All right, defense.
Yes, Your Honor. May it please the court, counsel for the prosecution. Good morning. How are y'all today? The first thing I want to say is the charge of the court. I'll remind you that goes with you to the jury room. So don't worry about trying to remember what we said, what like that. It's all in here. The judge has the law. The lawyers have their duties. The state wants to convict Vernon Dixon. Okay, they want you to find him guilty. Remember that what we talk about here, we lawyers, is not evidence. Okay, evidence is that which the court admitted from the witness stand. We all have our views, we all have our opinions, but what we say is not the evidence in this case. The real bottom line here is, what does the evidence say? Okay, what does the evidence say? The state produced a video in this case. And you have to look at the video. And the state has alleged that the murder occurred at 3 o'clock with 49 minutes and 41 seconds. Look at the video. Because some of the witnesses said, oh, he did it. And some of the witnesses say, we don't know who did it. What's that? That's a reasonable doubt. That means that the state has not proven this case beyond a reasonable doubt, as they are required to by law. The video. Some of you think maybe he did it. And some of you are wondering, did he do it? That right itself, that in and of itself creates a reasonable doubt. If you don't know who did this, then you must find him not guilty. I've looked at the video. Y'all have looked at the video. Look at the video again, and in your own mind, decide, do I see Vernon Dixon shooting the gun and causing the unfortunate death of Avante Boyce? I can't tell you that. You have to decide the facts in this case. The bottom line is you have to decide the facts, and you have to decide maybe he did it. Maybe he didn't. What we don't know is that there's at least half a dozen people there present. We don't know who shot Avante Boyce. And if we don't know it, you don't either. That, ladies and gentlemen, is the reasonable doubt that you have to go back to the jury room and make your own mind up. I'll remind you of some of the instructions in the charge. Each of you has to make up your own mind. I don't want you to say, well, I'm going to go with the rest of the jurors because I'm in the minority and they're a majority. Each of you has to make up your own mind. We want to go ahead and thank you for your service in this case. We want to thank you for your verdict. We look forward to hearing back from you.
May it please the court, state. Good morning, ladies and gentlemen, and thank you all for being here. It's been a long, I think this whole thing started about a week ago, and we understand that this was not an easy sacrifice for anyone, but without you, this whole process can't happen. We're here today, State of Texas versus Vernon Dixon. Mr. Schaefer told you is correct. Burden of proof in a case. The burden of proof is always on the state to prove, and they must prove each and every element of every offense. If you have reasonable doubt as to anything, any of the elements, whether this happened in Bexar County, a date, any of the elements in there, then you must return a verdict of not guilty. And that goes for all three counts of murder, felon possession of a firearm, and tampering with evidence. Remember, we talked about in Wardire levels. We have reasonable suspicion on the very far end. That's enough for a traffic stop. Beyond that, we have probable cause, which is burden to arrest. And that's less than 50%. Beyond that, we have preponderance of the evidence, which is just a little bit more than 50%. Beyond that, clear and convincing evidence, which is, excuse me, you see this in a CPS case, Child Protective Services. It's enough to remove a child from a parent's home and place them with a new family. And then beyond that, we don't know exactly where this level is. We leave it to each and every juror to decide for themselves, is beyond a reasonable doubt. It is the highest burden that we have, and it's the highest for a reason. Because what you're deciding here today is life or liberty for somebody. This is the only kind of offense, criminal offenses, that can result in somebody being thrown in prison, thrown in jail. And for that reason, our laws say that you must be convinced beyond a reasonable doubt. What is presumption of innocence? I think we told you at the beginning, it's the only presumption that carries through a verdict, through a jury trial, all the way until a verdict is rendered. As he sits there today, Vernon Dixon is presumed innocent. And I'm going to suggest to you that the state failed in their burden to prove beyond a reasonable doubt that he is guilty of any of the offenses today. And why is it important? It's because it's the only presumption we have in a criminal case. It's what protects us all. Again, we talked about three possibilities: guilty. This analogy, you have a horse race and it's a runaway. You have guilty, not guilty, and then you have this last one, not sure. You look here, if you remember, it's like a horse race in the moment, kind of hard to tell, somebody won by a nose. If you are unsure, if you're left there with a doubt, that is your doubt. That is your reasonable doubt. And not sure is not guilty. I'm going to talk about what you have. You have a blurry video, and Mr. Schaefer mentioned it. Go back and watch the video. It's admitted in evidence. You can watch both of them. Take a look at it frame by frame if you want and see. You do not see the shooting on that video. You cannot tell who killed Avante Boyce that day. And uncertainty is reasonable doubt. I think I told you in opening that this is a case of missing pieces. The state is going to present evidence, but they're also going to have a lack of evidence. In this case, we have no fingerprints, no weapon, no GSR. Do you remember GSR? We had, I think, 3 witnesses talk about it. Gunshot residue. You remember what Dr. Kanan said? Said that at a close quarter shot, something that happens so close range, you should see GSR on the burn wound. Even at a close range, it should be there. And you'll have the photos. It was not there. So does this match up with the state's theory that Vernon Dixon in close quarter shot and killed Avante Boyce? I'm going to tell you it does not. Again, you had multiple people under that pavilion, multiple people that could have been the shooter. Talk about witnesses. You had Versa Austin, aka Juicy. They stayed kind of on the stand for a long time. At one point, they were arguing with him. He's about 15, 20 feet away from the car. He says very clearly, I did not see who shot him. And he's there with the perfect vantage point. You have Mr. Carl Cunningham. He said he saw something, but he's across the parking lot. Remember the photo they presented. That's also an evidence to you guys. He sees something going on. He hears a shot, but does he have a clear view of what actually happened? And my suggestion to you is no, he does not. Donald Neely goes by Raven. Said Vernon handed off the weapon to him, yet he's remained silent about this for over a year. He says something along the effects of, I didn't think it was important. No one ever asked me. Well, does that make a whole lot of sense? If you had something as important evidence, he admitted, yeah, I knew there was a shooting. Yeah, I knew something went on. Oh, by the way, this happened, but I didn't bother telling anyone about this until just a week ago. Why does that make any sense? And the answer is it doesn't. As for motives, we don't know. The state's not required to prove motive, nor is the defense. And lastly, we talked about Dr. Rajesh, come on. Said 2 wounds, 1 fatal. We're not questioning the cause of death here. This was a gunshot wound that killed Avante Boyce. However, what was missing? No powder burns on the skin, which again, even through clothing at a close range with a firearm, 2 shots you should have seen, and we did not see it. This refutes the state's theory that this was a close range shot. And does this match up with the video? Someone as close as Vernon could not have made that shot. However, there's other people in the pavilion in that instant that very well could have been the shooter. Think about just the overall mood that day. There's high flying emotions and anger, and that makes for questionable testimony. We're going to come back to that. You heard that there's a fight. The girls are all fighting. And who's trying to break up the fight? You have Vernon, you have Avante, and they're breaking this whole match up. Everyone's in the car. Things seem to be cooling off. And then for seemingly no reason, they want you to believe that Vernon gets out and shoots and kills Avante in cold blood. Ladies and gentlemen, that doesn't make sense, right? We're going to tell you, don't leave your common sense at the door here. Nothing about this murder, about the offense here, the way the state is presented, matches up the evidence or makes sense it just doesn't pass the smell test. And remember, uncertainty leads to reasonable doubt, and reasonable doubt must lead to an acquittal. I think I told you at the beginning, this is a case of what's missing, and what's missing in this is absolutely crucial, right? You have bits and pieces of a puzzle, but you don't have the full puzzle. And you cannot convict, you cannot follow your oath and convict Vernon Dixon based on only partial picture, not in this case. We're going to ask you to return the only verdict which makes sense, and that is not guilty. I just want to talk to you a little bit more like I said, you've heard from a total of 15 or 16 witnesses in this case. And yet you're left, in my opinion, we're left with more questions than we have answers. We have a lot of questions left on this case. And again, we told you certain facts are not in dispute. Avante Boyce is dead, and that is a tragedy. No one ever deserves to lose their life. You heard from Evie Lewis, and it was the first or third witness that was called after 2 officers. She testified there's a fight, only 2 people trying to break it up. And again, does this make any sense at all? That somebody just randomly gets out and shoots and kills a person that just moments before they were working with? Or does it make sense that possibly there's a shooting, someone else is a shooter, and you just kind of jump to a conclusion? You make an assumption, yeah, this is the person that shot him. Think about Evie's vantage point. Back seat, Vernon's up by the front of the car. I'm gonna suggest to you that if she heard a shot, your brain puts 2 and 2 together, and it just doesn't match up. We talked about Versa Austin. He's standing there 15, 20 feet away. They had him on stand a long time. At the end, he had to say the same thing. Vernon did not shoot. He did not see Vernon shoot. And that's important. He's an eyewitness. He's right there. And he has the vantage point to see. And he's telling you that he was unable to identify him. Again, when you have inconsistent testimony, you have questionable testimony, it leads to doubt. And that's what you must infer and reach reasonable doubt in this case. And that is what we have. And that's what I told you at the beginning. That's what I'll tell you now. The state has failed to meet their burden. You may think, again, you can be 50%, even 60, possibly 70% sure we think this happened. But reasonable doubt is all that matters. And I'm going to tell you, I don't think the state has reached their burden. They have not proven this case beyond a reasonable doubt. Emily Dixon, she was on the stand. Again, motions are high, kind of combative, but her answer was plain and simple. She did not see the shooting herself. And then we come back, we talked about Dr. Rajesh Kannan. He testified homicide by shooting, however, no GSR. And again, we cannot stress to you how important that is. Close range shot. Based on the video, they're saying that they're in close proximity, mere feet away, possibly just a foot or less. You should have seen GSR transferred, and yet you don't see it. And again, why is that important? It's because it does not match up with the state's theory of the case. It leads to reasonable doubt. And ladies and gentlemen, it leads to the only verdict that we think you can legally and justly return, and that is a verdict of not guilty. Once again, thank you very much for your time, your patience, and your consideration throughout this whole process. You've been great jurors, and we appreciate your sacrifice for being here. No, Mr. Garahan's going to speak with y'all. Again, thank you. We'll thank you for your verdict and respect your verdict. Have a good day.
Yeah, Your Honor.
Yes.
Defense counsel.
Counsel.
Ladies and gentlemen, I'll be the last one to talk to y'all today. And then you will go back to the back and deliberate on this case. And I'm going to briefly go through some PowerPoint because apparently that's what all these lawyers do now. So I felt that I need to do this. And let me make sure I got it. Okay. Elements of the crime. Daniel's already gone over this and y'all have seen this many times, but I just wanted to reiterate these elements. The date is not in question. Bear County, Texas, you heard officer testify to that. Defendant has been named in this case, intentionally and knowingly, that's up to you. But the fact is, I think beyond a reasonable doubt, we met that burden many times over in this case. Causes of death, we have that victim, Avante Boyce. We have that already. The fact is that it was done by a shooting, and as defense counsel said, it was done with a firearm, a shooting, and it's a deadly weapon. That's paragraph A. Paragraph B, if you feel that's appropriate, that's fine. Act clearly dangerous to human life, shooting at somebody that's sitting in a car, that's act clearly dangerous to human life. I'm going to go on to count 2, unlawful possession of a firearm. Again, date, Bear County, Texas, the defendant, that's not in question. Possession of the firearm, again, that's part of the elements that we have to prove for this count 2. Without a question, he's been possessed of a firearm. Many witnesses already testified to that. Many witnesses, 4 to be exact. After a felony conviction, which defense has already stipulated that he has a felony conviction that's passed, You'll see that felony conviction, the judgment, that it's been over 5 years since he's been off for parole or community supervision or imprisonment. So the fact is, it's already after that 5th anniversary release from confinement or probation. So that's not a question. It's a public place. This is a parking lot. He is not to be possessing a firearm for the rest of his life anywhere other than his own home. In this case, it was in a public place, which is a parking lot of that common area. Tampering with evidence, again, the first part's already established, but knowing an offense had occurred, he knew an offense had occurred. At least at that point, he knew an aggravated assault with a deadly weapon had occurred because he had shot at another individual with that deadly weapon. That is an aggravated assault with a deadly weapon. That's a felony. Intentionally and knowingly concealed this thing, the firearm, which he did. I mean, you had testimony that he had from 2 different individuals that he handed the gun off to somebody else. You've seen it in the movies. Why do you hand a gun off? You get rid of it. Get rid of the evidence. What are you going to do if something happens? Somebody gets shot. You get rid of the evidence. That's what he was doing. He was tampering with this evidence. So again, count 3 is not a genuine question in this case. So again, I think defense counsel said it, and I said it during board ire. Don't check your common sense in at the doorsteps of this courthouse. It's common sense. Use your reasonableness to get that beyond a reasonable doubt. In this case, the state's confident that this is beyond a reasonable doubt. There's not a question of who killed Avante Boyce. It's not a question. Your common sense tells you that. Your common sense tells you this man over here sitting is the one that pulled that trigger that day. And how do we know that? Let's talk about the evidence in this case. Testimony of witnesses. Not one lay witness, meaning a person that's not law enforcement or the ME's office or CSI. Not 1, not 2, not 3, but 7 different witnesses on this case came in. 1, 2, 3, 4 are related to the defendant. His own family came in. Call her Evie Lewis. His stepdaughter, person that he considered his stepdaughter, came in, testified. Who is Avante Boyce to you? She was, I consider that my husband. We have children together. I was pregnant at that time. I had my second one after he died. But what do you consider the defendant in this case? That's my dad. Known him since I was 7 or 8. And she points the finger at this individual. Within feet of her child in the back seat with her, this man here takes a gun and shoots Avante Boyce while he's sitting in the front of that vehicle trying to get out from this man. And he knows he did it because the fact is he was there in that white jumpsuit. He knows that. The fact is, you know that. His stepdaughter knew. And that little boy in the back seat with her, Avante Boyce's son, was within feet of his father being killed by that man over there. She testified to that. Now let's go to Unique, or I'm Unique. Biological daughter of the defendant came in and testified. Raise your hand, Dad. That's him right there. Yeah, she was angry. She didn't want to be here. We had to drag her in, but we brought her to you. And yeah, she was not the most hospitable. She was a little hostile at times, right? But one thing that came out was the truth. Saw my dad with a gun coming around. He had that gun. He was mad at me, pushing me when we were arguing with his stepdaughter. That, by all accounts, she doesn't lie. That's fine. But she came in and testified, Dad had a gun. You'll see on that video, and you'll see that still photos of that video, that she's on this side of the car. So yeah, maybe she did not hear what happened, or I'm sorry, see what happened, but she dang well heard it. And as soon as that happened, who came around that car? Vernon Dixon, with a gun in his hand. Go on to Donald Neely, her husband. What did you hear him say? When Vernon Dixon came around that car, he said, "Look what you made me do." I want you to remember that phrase. Look what you made me do. He said he handed the gun off to him. He was scared. He's the son-in-law of this man over here. The son-in-law, another family member. Go to Pearl Barnes. She was there at that scene. He's looked at that video. Pearl saw everything that happened. But who is going to come in and testify against their own child? That's his mom. I understand that. You understand that. She was there. She was watching. She saw him. She took him from the scene. She said, "Why'd you do this?" Remember that. Carl says that. Heard a woman's voice coming from that car as it sped out of the parking lot. "Why'd you do this?" Plain and simple. That's his mom. Go on to Versa Austin, aka Mr. Juicy. It's homeboy, right? Who's going to testify against their homeboy? Juicy was certainly not going to testify against his homeboy. We all know that. He looked down the whole time, didn't want to look at, make eye contact, was not cooperative. The judge informed him to answer the question several times. Last question I asked him, "Are you scared?" Yeah, he's scared. He has to go back and live over there. He has to walk around those streets. Yeah, he's scared. Go on to Carl Cunningham. Independent witness. Just a maintenance guy. Took that picture of this individual over there in that white tracksuit. Very identifiable, might add, the white tracksuit. He's testified that that was Keno, knew him as Vernon King, and then that last phrase, he said Vernon King Dixon. Saw him with a gun, saw him shooting that car, saw him come around and hand that gun off, get in that car and take off with his mama, and heard her say, "Why did you do this?" Belinda Boyce brings in something very interesting, a voicemail, what I call the butt dial in this case. Let's talk about that, the additional evidence, but I'm going to skip to the voicemail. The voicemail. What was said on that voicemail? You can't hear a lot. It's a little mumble jumbled. I mean, if anything, you need to listen to that again. But one thing you will listen and hear on that, something that sort of goes with what Donald Neely said. On that voicemail, you will hear, they made me do it. What did Donald Neely say that the defendant said when he came around that car? Look what you made me do. Listen to that voicemail. It says that. We already heard from Evie that that person is Vernon Dixon saying that. That corroborates between Donald Neely, what he testified to, and that voicemail. That's a match. Another match in this particular case is Carl saying that that gun was handed off to who? Donald Neely. Why would he make that up? That leaves credit to Donald Neely of what he said. You look at these pieces of evidence that come in, those puzzle pieces, and they're falling into place. Clear cut. It's beyond a reasonable doubt. It shows that those puzzle pieces make a very clear picture. The security video in this case, without question, hey, I would love to have a video of every murder that I ever tried, or for that matter, any murder that ever happened. That would be great. But this is not a perfect world. This is not a perfect scene. The fact is, we don't have the actual shooting, the smoking gun in his hand. But you got testimony that's credible, that you match it up with another puzzle piece, which is the videos on two different angles. And it's very clear. It's beyond a reasonable doubt.
5 minutes.
Thank you, Your Honor. The white tracksuit, which I really, in this case, seals his fate. So identifiable from across the parking lot. Yes, there might be a tree in Carl Cunningham's photo, But what you can see clearly through that tree and those leaves is a white tracksuit standing there with his arm up. It's clear as day. Talking about GSR in the defendant's vehicle, there's GSR on the headliner and GSR on that seat where Avante Boyce was killed. No GSR was ever found on his hands, meaning that he most likely did not possess a gun or anything. And in this case, there's been no evidence that Avante Boyce did anything except for try to stop a physical altercation between females at the scene and got shot by this man senselessly. Bullets that were found in Avante Boyce came from the same revolver handgun. You heard the doctor in this case testify to that. You heard the lab technician scientist come in and testify to that. Both shots came from the same gun. The defendant fled from the scene with his mom. It's not a question. And then he fled to Kansas. You can use that as guilt against this individual. If you flee a scene after you shot someone, you're guilty of murder. In this case, he's guilty of murder. You're going to see in that video, if you need to watch it again, but you've seen it several times, but there's several different clips. I put still video photos in so you can look at the times on those still videos or photos and be able to match up for the video. But you've seen the video several times. Mom arriving. Defendant in that white tracksuit identified. That white tracksuit again. You see it from across the whole parking lot, that white tracksuit. Again, photo by Carl. White tracksuit. You see the defendant at moments after the shooting. The defendant's on the other side of that car. I put two yellow circles on this in particular. If you look at this, the circle to your left, all the way to the left. You know who that is? Mr. Juicy. Because what did Mr. Juicy say? One thing that he said over and over and over, if I hear gunshots, I'm running. I'm out. He's all the way across the parking lot. Gunshots have happened. Victim is laying outside that open car door, and the defendant is coming around with that gun in his hand, and everybody else is standing there. And I don't know if you can see this, but I'm looking up there and I see Miss Pearl right there in the middle, leaning up against that picnic table. Because if you watch the video, Pearl walks to that car. She identified herself. She saw the whole incident. Right after, the defendant handing off the gun, circled in yellow there, to Donald Neely. Pearl and the defendant leaving that white tracksuit, get into that car. And if you did catch this video right here, the still shot shows that white tracksuit hand. Again, there's that white tracksuit following him throughout this case. Him pointing to his mom to take a right. The puzzle pieces equal a clear picture, and it points in one direction, only one. It's that direction right there. Vernon Dixon shot Avante Boyce for no damn good reason. It's senseless. It was stupid. And yeah, it doesn't make sense. But use your common sense and your reasonableness in this case. The defendant is guilty of murder on count 1, unlawful possession of a firearm on count 2, and tampering with evidence on count 3. Plain and simple. Vernon Dixon is guilty of murder, and hold him accountable, please. Thank you.
All right, ladies and gentlemen, you have heard all the evidence that you're going to hear in this part of the trial. So I'm going to send you back to the jury room. But before I send you back, if I could have Miss English and Miss Priest, please remain. All right, everyone, please rise for the jurors. All right, everyone, please be seated. Defense and state, if you'll come with me this way.
Hey,
I know. I was funny. I was trying to think. It's funny because like you really said all the years, you figure it would happen generally, but I guess it does sometimes.
We're good.
You've ruined your parking lot back there.
Oh, it tends to happen, right?
Yeah.
Oh.
Oh, 'cause we got a crowded courtroom. Yeah. Deputy Mejia.
Oh, yeah. I saw that. I was like, "Ooh."
I was like, the second she started doing that, I was like, oh, she's one of the ones.
No, I can't.
Well,
All right, thank you.
I agree. She sent it to me.
All right, everyone, please settle down. Not too loud. Alexander Castro.
Yeah.
All right.
but I just took it all out. So I'm just trying to put it back in order since I took it out.
Andrew Arnett. Andrew Arnett.
Anything out of there. So, yeah.
Anthony White. Anthony White. Heather Martinez. Heather Martinez. All right, so defense, if you will confer, remember the rules that the court has. Do not approach the bench unless you've conferred with the state, conferred with your client. If your client is in custody or you need to have your client brought out, once you've requested them, do not leave the courtroom. Let the clerk know if your client wishes to speak in a language other than English so we can call the interpreter, and whether or not you speak the language, we will still need an interpreter. So everyone, please confer.
Back in order. So I didn't take anything. Yeah, I didn't take anything else out of there. And this was the only thing I took out. So I don't know. You want me to put it back in there? Actually, I didn't even open that. Okay.
Dinah, do you need my list or no? Okay. Yes, please. Oh, no, no problem. Thank you.
How you doing, man? Looking good. You might just-
Okay. All right, thank you.
Yeah. Are they open? I think so. I think for the moment.
Sure. Okay, I know the defense needs to confer with the state, so once they confer with them and let you know they're ready, then you can bring them out. Yes. You're welcome. Oh. No, we're fine.
Yeah, I'm just gonna step.
Hello, hi. Good to see you. All right, thank you. She's off enjoying her life. Yeah, I always say people need to take some time, take some vacation away, even if it's a staycation, although they're cruising, so. Yeah.
Have a seat, guys. Have a seat.
I'm not sure when she's gonna be back. I think if they win the lottery or something, they may not come back. All right, thank you.
You ready?
Oh, no, no, I was gonna put you.
No, no, no.
I promise you I'm not making that up, although I could be remembered incorrectly. He was supposed to get 15 out of Hayes County. I had to send a little works in on it yesterday because I'm trying to go that down. So, but anything else. Okay. I promise you said that you thought 15 is the right thing. I'm not saying that you still think that's the right thing. I'm just telling you that that is my memory. Okay. And Judge recalled it for Stephen Estrada.
Hello, who are you here for?
That's all right there.
All right, I'll call you. You need to be behind the line.
I just where I'm.
Yes, that's where you are. Oh, no, you've been in here before. I'm the same. Like, where's your client?
Tell me when you're ready.
All right, have you conferred with the state?
CR 11010. You may have several cases. I wouldn't be surprised. Yeah, he has two.
Okay, well, you'll need to file a motion to withdraw. So, well, if you want to go do that, okay, and then we'll take care of your case when you come back.
He's bad at aggravated.
Yeah, what time are you gonna have it done? Okay, well, let's do that. Okay. And tell her, because it's being filed online, it'll take a while. So tell her to fax a copy to the court. Sure.
Okay, okay. I know he's getting 15 out of days, and this is one of these typical things where I come up with a plan that would work.
So how are you doing?
I wanted to plead in Hayes first because he doesn't trust Hayes. He trusts us, but what he
Oh,
thinks is
yeah.
that every single here is for them. And you know what? You might be right. So. Do you have the file? I think you grab the files you want to see. If they got recalled today, they should have. Good.
Way back there, man. Way back there.
I almost texted you and asked for your help yesterday, but I found something.
Have a seat, okay?
But you're on my.
All right, well, we'll take care of that later. I mean, file your motion. Okay, and then we'll come back. Yes.
She was the response. GPS
Yeah, it's gonna be a little chaotic today. Well, that, and I find that when you don't give instruction early in the morning, people act as though they've gotten instructions, and then everybody is just, it's chaos. Diana, have the exhibits gone back? All right, you want to check if Mahia is out? So that we can do what needs to be done. Hello. Okay. Oh, no problem. Okay. Yes. Okay. All right. And away we go. Okay. All right, I've started it.
They said the bond on the other one, 2,000. Oh, no, the balance 20 then. Yeah. They charge you 10%.
Oh, thank you so, all right, thank you so much.
It's been very nice. Yes.
They still don't know anything about it. I appreciate, I really appreciate it. Very much.
Well,
Gerald,
so I.
all right. All right, thank you. Oh, no, I appreciate that. Everyone, the court is recessing at noon. Zach is like, I've been holding fast to my noon timeline only because my mom is saying, I'm going to call you if you don't recess at noon.
Pat Priest had a weird way of putting it. He said, if you can't tell by my profile, I don't miss many lunches. Let's move things along a little bit.
Okay. Could I see the files on Terrence Bowie, please?
Okay. You know, I said something really smart. He's probably doing it. You know why he did that? Don't you really? Getting the coin settlement. You know, 10 years ago, that might have been hard. These days, just show me how to get from point A to point B.
Oh, yes. Hi, all right, how's it going? All right, what's the name of it?
I think it's just
Yes,
woman.
186, yes.
Wasn't really-
Oh, did your client show? All right. All right, I'll check him on. Oh, well, we'll see about getting them down here.
Yeah, I'll bet you. Is that one, is that publicly they do? I learned a lot of things there.
dude, we gotta go, so, yeah, we should.
Sure. All right, we'll do. All right, thank you. Jaro Rivaro. Good morning. So did you confer with the state? Do you have all the discovery? Everyone, please whisper.
I spoke with the state, it seems like there may be, they're gonna look into intentions and EMS records that must be added to discovery. They're looking for that first.
All right, are there EMS records?
So we're about 95% sure there's not. In our communication with the complainant in the post office, she keeps mentioning, like, I need something for my face, like medical, prostitution or health. So, you know, police report and the evidence, everything we've checked, we can also agree that there is no mention of a hospital visit. We just wanted to dot our i's and cross the t's. So we can even come back as early as a couple of days next week. You're on here. We just want to make sure.
All right. Have you been able to tender an offer or no?
We have just.
Okay. And how old are you? How old are you? All right, Lance, if you'll recall this back at the end of the month for a plea deadline. All right, so we'll see you back here on November 28th. Once you sign the reset form, you're excused. And thank you for dressing appropriately for court. All right, once he signs the reset form, he's excused.
Thank you, Judge.
You're welcome.
Yesterday, you messed me too.
All right, to the attorneys, there's someone in the box who's not a defense attorney, and you're all blocking the line of sight of the deputies.
Neil, she's telling you to lose weight.
No, I am not. I am not.
I will be later.
Thank you.
You're winning.
We're engaged.
Oh, that.
Neil, congratulations, Judge. I'm sorry.
Yes,
I think we're ready on that registration.
yes.
Thank you.
All right, Mr. Bowie.
Come on up, sir. Youth counselors. Gotta come through.
All right, Mr. Bowie. With regard to your cases, there are two that I'm going to magistrate you on. The magistrations are the same in each case. So I'm going to give you the cause number for each case, and I'm going to tell you what the charge is in each case. But I'm not going to repeat the magistration twice. You understand? Because the magistration warnings that I'm going to give you are the same for each case. All right. In 2023 CR 8726, you're charged with the offense of possession with the intent to deliver a controlled substance, penalty group 1 gram to 4 grams. And in 2023 CR 8725, you're charged with the offense of possession with the intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams. Do you understand? All right. You have a right to remain silent. That means you don't have to speak to anyone. You have a right to retain counsel, so you can hire an attorney if you so choose to, and if you can afford one. If for any reason you can't afford an attorney, I see Mr. McCrum is here. You're his attorney?
I am.
All right. So I have to let you, even though he's present, I still have to give you all of these warnings. So if you can't afford to hire an attorney, what will end up happening is you'll have to fill out a document. It's sort of like a resume of your finances. And they will make a determination based upon that, whether or not you qualify to have an attorney appointed to you. That document that you fill out will be done under oath. So they'll swear you in and swear that everything is true and correct. Do you understand? You have a right to have a reasonable time and opportunity to consult with your attorney. So you have to be given time to talk to your attorney. Do you understand? Okay. You have a right to have an attorney present during any interview with a peace officer or with any prosecutor or anybody for the state. Once you begin an interview or talking to someone other than your attorney, be it a prosecutor or an officer or peace officer, you can stop that interview or terminate it at any time. You are not required to make any statement to anyone, but if you do, that statement could potentially be used against you in any type of proceeding. Do you understand? You have a right to an examining trial. These cases have already been indicted. If you're a foreign national, you have a right to have access to your consulate. The procedures for requesting a court-appointed attorney, I've already explained to you those procedures. Once you qualify for a court-appointed attorney, that attorney has to reach you by the next business day. So today is 10:25 a.m. That attorney, if it were one appointed to you, they'd have to reach you by 10:25 a.m. Do you understand? All right. Do you have any questions about anything? All right. Do you wish to have an attorney appointed to you? Okay. All right. What I'm going to need you to do is I'm going to need you to sign. By signing, you are not admitting to the offense. This is just stating that I've gone over the rights with you and you understand them. Do you understand?
I appreciate it.
Yeah.
All right. And so he has 3 cases. The other case, I'm assuming he has a bond on. Is that correct? All right. So next we need to talk about a bond setting in each of these cases. Is there any suggested bond? All right. So what I need to do, Mr. Bowie, is I'm going to need to go on the record and I'm going to have to ask you some questions. And the questions are not about the facts of the case. It's related to the bond. Because the way the law has changed, there are certain things that I have to know about you in order to determine that this is an appropriate bond and what conditions to add for you. Do you understand? All right, we're going to go on the record, Diana. We're going on the record in 2023 CR 8726 and 2023 CR 8725. Off the record for a moment. Oh, Lance, you see, there's shouting in the back hallway or something? Oh, okay. See, my allergy ear is acting up. We're back on the record. State of Texas versus Terrence Bowie. Can I have parties announced for the record for the state? Defense? All right, off the record, the state and the defense have agreed to a bond of $12,500 in each case. Is that correct, state? Defense, is that correct?
Yes, sir.
All right, Mr. Bowie, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, Mr. Bowie Jr., have you ever had any type of mental health diagnosis? Have you ever been under a psychiatrist or psychologist care? Have you ever had any type of drug use, be it marijuana? Okay. And how often were you using marijuana? Okay. Do you have a place to stay? And are you living there with someone? And who are you living with? Anyone else in the home? Are you employed? What do you do? Oh, I never heard of Bimbo's Bakery. Oh, you make what? Oh, wow. Okay, I need to stop. That's one place. See, I'm trying to diet. That's one place. We do. All right. Is there any other questions from either side? All right, then each case, I'm going to set your bond at $12,500. What I'm going to order is I'm going to order 90 sober meetings in 90 days. That's AA or NA meetings. Now they call them sober meetings. You can do those by Zoom. They're all over the city and all over the county. Your attorney can let you know about that. Oh, just one moment. And I'm going to order UAs for you, but I know marijuana stays in the system for a time. So I am going to have UAs for you, and those UAs are going to begin on December 15th. Do you understand? Yeah. And I'll waive fees. Do you all have a whiteout? Thank you. I have to be very detailed in my instructions, otherwise they're going to call back. All right, counsel, where are we on the cases?
On the cases?
Yes. I mean, have you conferred with the state?
Oh, not in part like that. I have.
All right, so if you want to confer with them, because he's on the docket today, and I know you probably want to take him down to the satellite. All right, so I'll let you take him down to the satellite because I know they have a time constraint on them, but then I'm also going to need you to confer with the state. All right.
So they'll take them down and I can.
Yes.
Yes, sir. Yeah.
You're welcome. Jose Posadas, Maya. Yeah. Who's the attorney on Jose Posadas? Hi, thank you. Come down. Where are they? All right, come down. Hello. Hi, all right. So where are we on this case?
We're waiting on one. They called their yesterday. They informed me it would be about 4 months or 7 weeks. process these, process the items submitted from the case. That's where we learn and all the evidences.
All right, so is that the only outstanding discovery?
Yes, Judge.
All right. There's no citizenship issue, is there? All right. So Lance, on Posadas, we're gonna need an immigration. Are you appointed? Okay, awesome.
It's today, though.
And he's not gonna need an interpreter, is he? All right, everyone, just give me one moment. Hello? Okay. All right, no, I'll take care of it. I think Mahia heard you. All right, thanks. Bye-bye. All right, I'm sorry, you can come back. And Lance, on this case, if you can set it for the new year. So what we'll do is we'll bring it back in the new year and you all can continue to confer off docket.
Yes, ma'am. We've excused from.
All right, January 18th. Is your client anticipating on making bond?
No, Your Honor.
All right, is there a hold on him or anything?
Yes.
All right, so we'll be back on January 18th.
Thank you, Judge.
All right,
May
you're
we be
welcome.
excused?
Yes. Joshua Caldwell, y'all are not ready yet, waiting for her attorney to come back. All right, Samantha Richards. All right, so state on Samantha Richards. Oh, there you are. All right, do you have an order instead of this?
No.
All right, could I have 2 B pages? Each, yeah, just 2 other B pages. All right, so in this case, the court asked for specific information. Do we have that?
We do. I have Barbara Hood here from Alpha House.
All right, let's do that. All right. All right, everyone, please keep the well as clear as possible. Court is calling 2022 CR 3726B and 2022 CR 3725A, State of Texas versus Samantha Jean Richards. Could I have parties announced for the record for the state?
Anna Ochoa Nelson for the state.
John Young for the defense.
All right, and are you Miss Richards?
Yes, ma'am.
All right, so defense counsel is here asking the court to recall the warrant and reinstate the bond. Is that correct?
Yes, Your Honor. In the alternative, and I know you already told me you're not going to do this, I'm still going to ask for it. For a PR bond on these 2 cases, even though they are robbery charges, they are set for trial on the 4th of December.
All right, that will be denied. So do you have witnesses with regards to?
Her attendance at Alpha House.
Yes.
I have Barbara Hood here.
All right, if you'll call her.
Miss Hood? Good.
Hello. All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. If you'll state your name for the record.
Barbara Ann Hood.
All right. And off the record, excuse me, everyone who's behind the court reporter, please don't talk behind the court reporter. The deputy will move you to the other end. All right, defense.
Ms. Hood, was Barbara, I'm getting my names mixed up. Samantha Richards, was she in attendance at Alpha House prior to October 10th?
Yes, she was.
And was she successful in her stay at Alpha House?
Yes, she was in our residential treatment facility program.
And were you aware that she had been taken into custody after she left Alpha House?
I was notified by her sober living home.
Okay, because she was supposed to go to the sober living home when she finished Alpha House.
Yes, we had arranged that.
And on the 8th of October, was she still in residence at Alpha House?
Yes, she was.
And were you aware that she had a complaint filed basically with the court that she tampered with her GPS monitor?
Yes, we were notified that it had been tampered with.
Okay. Did you see any evidence of any tampering with the monitor?
I saw the monitor on her ankle. I wasn't aware of any tampering.
All right. No further questions to this witness, Your Honor.
All right, any questions, state?
No, you're.
All right. If she is released back on bond, will she be able to go back to inpatient treatment?
Yes,
All right, and will you all be able to arrange to pick her up from the jail?
yes.
Okay,
Your Honor, I believe she's supposed to go to the sober living facility.
I'm gonna want her in the inpatient facility because this has been a trauma. And usually when traumas happen, people end up going back to using. And of course, once she's placed in inpatient treatment at the Alpha Home, the court will, of course, leave it up to Alpha Home to make the decision when she should go to sober living.
We've made the decision. We're prepared to take her for an additional 30 days if that's what the court requires.
Yes. All right. Any other questions?
No.
All right. Thank you so much for coming in. I really appreciate it.
Thank you.
All right. Anything else?
No further witnesses other than my clients, Your Honor. If you have any questions about the alleged tampering, I would encourage you to ask her those questions, or I can.
No, I don't have any questions concerning that.
Did you tamper?
Well, if you have questions, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Samantha Richards?
All right, defense.
Did you tamper with the monitor?
No, I did not.
How did you find out that there was some complaint from pretrial services?
On October 8th, I was working in the kitchen and I was taking the trash out. It was a little after 5 o'clock. I had jumped in the dumpster by myself. I took it upon myself. I was trying to be of service. It was overflowing. We had food bank the prior day, so it was overflowing. So I took a rake and I got in there and I started smashing it down. My foot disappeared in there. There's only a logical thing that I could think that set it off. It hadn't went off in a long time. I've had the monitor on for quite some time, and it has went off before I was at Alpha Home, and they were always able to reach me because I had my cell phone. So I've never had a 24-hour number to contact to reach them in times like this. So they were aware I was at Alpha Home because I would not be allowed to be there. And they attempted to contact me by my mom's phone and by my sober living house that I was moving into. And they weren't able to get a hold of me. I did receive a message from the house, and October 8th was a Sunday. It was my birthday. I did receive a message from the office from my mom saying that to call the monitor, and I attempted calling Freddie Williams and I couldn't get through. I left a voicemail. I tried calling my mom back. I got a hold of her the next day. She said her ringer was off. I called 8 o'clock on the dot Monday morning. He said that there had already been a warrant issued for my arrest to call my attorney. So I called Mr. Young, and asked, what do I do? He said for me to come in Tuesday morning. I came in here. He was not here yet. I came in here. I didn't know what the procedure was. He notified me that I should have waited for him to get here. But I came in here and you were not in there.
And Judge Angelini revoked her bond, increased her bond,
Increased
and
it.
would not reinstate the bond, and had her taken into custody.
All right, so here's my question. Why were they not able to reach you? Where were you? You mentioned it was your birthday. Where were you?
I was there. It was a Sunday. I was there at alcohol.
Okay.
Are you allowed to keep your cell phone?
No, we're not allowed to keep our cell phone. And if anybody calls for us, they cannot confirm or deny that we are there because it is privacy. So they couldn't release that information. And my mom, when I spoke to her, she said that the ankle monitor people had called her and said that they didn't know how to get a hold of me. Like they didn't know what prompts to follow. So that's when she had offered to relay the message. And unfortunately her ringer was off and I couldn't get a hold of nobody. I know in times like this, in times like that, if you can't get through, at least leave a voicemail, because if you don't leave a voicemail, there's no evidence that you attempted to do what you had to do.
All right, any other questions?
No other questions?
State, any questions?
So alcohol was a place that you were allowed to do that, correct? Yes. Okay. And do pretrial services have your cell phone? Did you give them your number?
Yes, they do, but my phone is kept in a lockbox in the office at the alcohol.
Okay. And you said that you were not picked up on this offense. You came into the courthouse. Is that right?
Yes, ma'am.
Okay.
I came in Tuesday.
And did you attempt on Tuesday to call pretrial services?
I did speak with him on Monday. I spoke with the pretrial officer. He asked me if I got everything straightened away. I said my attorney advised me to come in on Tuesday. He switched my location, my address from the Alpha Home to the sober living that I had gotten accepted to, and I had moved in.
So you did end up speaking to somebody from pretrial services on
Monday. No, on Monday.
Okay.
On Monday morning. I called him 8 o'clock on the dot. And we could call him to confirm that he should have a voice. I left him voicemails on Sunday evening.
Okay. So the Monday, would that be October 9th? Does that sound
Yes.
right? So I have a letter here from pretrial services on dated October 9th. And it says, as of this write-in, the defendant's whereabouts are unknown.
I have the same one and mine says October 8th.
No further questions.
All right,
No
anything
further
else?
questions, no further evidence.
All right, so with regards to bond, State, are you opposed to the defendant having a bond? And defense, if you're asking that the court reinstate the bond, you will have to call the bondsman and see if they want the bond reinstated.
Yes, Your Honor, and I am not sure about that. I know my client has tried to contact them, but I'm not sure what their answer has been to that.
All right,
Judge, we are not opposed to bonds.
all right, so this is what we'll do. If you'll get in touch with the bondsman, see if the bondsman has any objection to the bond being reinstated. I will reinstate the bond with the same conditions of GPS, and she's to reside at Alpha Home. So if you all want to make that phone call and let me know. Otherwise, if you all want to discuss a bond amount, you can.
But if the original bond is reinstated, that I should be able to just get rid of.
All right. I will come make that phone call, Your Honor.
Okay. And then we will continue. All right. Anyone else ready? We are recessing at 12 o'clock. And I can tell you, do not rush the court at 11:50 because it's not going to happen.
Yeah, folks, that on off docket matter.
What is it? It's for a bond or something?
It's the request of bond if somebody's been in jail for 60 days. I think you have the pages up there.
Oh, if you will, on that one, if you will go to Judge Nahara, he'll take that up.
Okay. The state recommended on what the bonds were. Thank you.
Alexander Castro.
Then in the middle, Mr. Captain.
All right, state, where are we on this case? I see that an offer was tendered, plea deadline date has expired. So is there a request for a jury trial?
So yes, Judge, but I did want to inform the court. So two things, we were talking to witnesses and there were internal affairs files in regard to this case. So we did issue the subpoena to the city of San Antonio. I believe the city of San Antonio or city attorney Jim Cobb filed a motion to squash the subpoena. So that's at least where we're at there. I was trying to find more clarification from our ethical disclosure unit regarding where the files are.
Well, what I can tell you somebody called Cobb and have him come in. And he's requesting, I think I saw that motion somewhere.
An in-camera review. Judge.
Yes, so get those documents to me and I will review them.
The second thing, Judge, so there was a cell phone, there were text messages involved in this case where we had a cell phone, we were able to obtain custody of the cell phone involved in this case. And so we did send that into SAPD to have a report done. That was done last week. They said it should take about a week or two, just depending on other cases that are in front of it or, you know, the busyness, I guess, of that department. So we haven't gotten that back yet. That is something that we found out about while talking.
All right, is there anything else?
No, Judge, not one difference.
All right, Lance, can you put this for the second week in December? Yes. All right, December 11th, once you sign the reset form, you're excused.
And I'm sorry, Judge, is that when we'd be set for trial or is that when we're
No,
taking up?
that's the cell phone. And you all need to make sure Cobb is here and that he's given those documents to me. Preferably, I would like those documents before December 11th.
Yes, Judge.
And so I'm anticipating the cell phone records will be complete. Defense will have those. And then I will review that.
Yes, Judge.
All right, is there anything else?
No, thank you.
All right, we'll see you back on December 11th. Thank you for dressing appropriately for court.
Martinez. Heather Martinez.
Just a moment.
No, Heather Martinez.
Yes.
I've spoken with Second Chance Bail Bonds, the bail bond company she had gone through.
Mhm.
They have said they will go back on the bond. If you reinstate the original bond. With
All right,
conditions.
let's put that on the record. We're gonna go back on the record. On Samantha Richards. Cause number 2022 CR 3726B and 2022 CR 3725A. Defense, as an officer of the court, you had a chance to talk to the bondsman?
I did. I spoke to her first name, I think, is Marnette. At Second Chance Bail Bond, they have said that if the court reinstates her bonds, that they will stay on the bond and she will be released.
All right, in each case, then the court will reinstate the bond. The court is still going to order GPS.
Can I ask the court to waive the fees on GPS?
Yes. It'll be GPS waive fees. And I believe she was on full GPS, is that correct?
I believe she was, Your Honor. Partial?
No. Could you check on that, please? I think it was full because yes, so it's full GPS. And you to reside at a half a home. And there's going to be a release to Alpha Home only. All right, and I believe your trial is set for December 4th.
I think it's fourth, Your Honor.
All right, is there anything else?
Nothing further, Your Honor.
All right, thank you. Thank you.
Okay. Give me a call when you get out.
Oh, I'm sorry. Can you, Lance, can you give her the reset form? I'm sure it may have been lost. But she's set for December 4th for trial.
Thank you.
All right, thank you.
But I don't see for the dash cam. The only dash cam I have is for the officer after him. I'm trying to see if you'll have any for the rates and the main portion. Now y'all may not have videos, I just don't know. And then use small 50 guys.
Well, that last file, I think Lance just put it up there. So I haven't gone over yet. That's okay.
I guess he's towards that area. And she may have some. She's reporting at the time.
All right, that one's done.
Oh, you know, the guy is.
Stephen Estrada. All right.
Judge, will Mr. Falcons be keeping his last name?
I don't know. We haven't discussed that.
Hyphen, I would suggest.
Okay. All right, Stephen Estrada, we were here for a plea, then we were not here for a plea. What is happening?
There was an additional case. They looked at that additional case, and changed their offer. I can't blame them. Mr. Estrada is not ready to take the offer. Admittedly, there was only made today. They said they would keep it open for another court setting. That's the information I'll have. I'll leave it for the court for a decision.
All right, how old are you?
32 now.
All right, you're 32. We're going to come back at the end of November and you need to let the court know whether or not you're accepting the offer. Do you understand?
Yes, ma'am.
All right, Lance, if you can bring this back at the end of November. November 28th. That's your plea deadline date. After that, the court will not accept any pleas without good cause. Otherwise, you have to plead open to the court.
Can I come on the 29th? I'm on vacation until I'm coming back in the town on the 28th.
The 30th.
Excellent. Thank you.
All right, thank you. All right, November 30th. That's your plea deadline date.
Thanks.
You're welcome. That one's done. Mari Fuller.
Special counsel.
All right, come forward. Mari Fuller. Hello. No. So you have all the discovery?
Judge, it's our second setting. I'm still getting discovery complete. I'm filing a discovery order right now,
Okay,
and so I'll need some time to get that done.
all right. And has the state tendered an offer?
Yes, Judge.
Is there any blood discovery or anything of that nature? That's what you're signing?
Yes, Judge.
All right.
Yeah, I'll get that on the file right now.
Lance? On this case for discovery, if you could set it in December. All right, we'll come back on December 11th.
Yes, ma'am. Thank you.
All right, once you sign the reset form, you're excused.
Judge, pardon my ignorance.
No problem. Thanks for putting the date on here.
Of course. The only thing the court's supposed to put on any paperwork is a signature.
Hey,
That's how I was trained, Judge.
I appreciate that. Yes. All right, thank you.
Double check.
All right, I will. Gerald, what is the wait time for DDRF inpatient?
More than 2 weeks right now.
Okay, all right, then I'll sign this for DDRF.
Go out to the right of the table.
Hello.
Judge, may I approach?
Yes.
I talked with the prosecutor about the case we did a plea on last week. Corpus. Can we approach you on that?
Yeah, just give me a moment. I just need to do
I'll
a
just be
couple.
right here, let me know.
All right, thank you. Can I see a prosecutor from Criminal Trial Division? Hi. All right, there needs to be a signature on that. And Hank, see if you all have any objections to this. All right, Linda Corley. Sure. So is there going to be any objection from the state?
I don't know. I just talked with him and he said we can approach and see how long it's gonna take.
Are there going to be any objections?
There will be.
Okay, so is your client on the docket today or is he?
Well, no, we did the fee and he's in custody waiting for ISA.
All right, so if you'll talk to Lance, have him set it and we'll have him brought over and put on the docket.
Thank you.
Sure.
Okay, thank you.
Thank you. John Albert Sanchez.
He's there.
All right, if he'll come up. Oh, who's the prosecutor? So there's a deadline for today for discovery.
Yes, Judge. I met with the detective on this case yesterday.
Mhm.
I had asked her to bring her case file on this one, but their digital case files now, apparently everything was digitized, so she didn't bring that. I will have to go over there to cross-check everything. However, I did ask her to tag the, he's not a co-defendant, but another involved individual, Nicholas Ojeda. I asked her to tag it with this JN number as well. She said she would do that, so that should be auto-populating already or later today. If it has not, then I will call her. In addition to that, we did receive the forensic interview from, I believe, Atascosa, so that is in our file now. And the detective had previously dropped off a phone dump from the defendant's phone. It was missing in the office. I was able to track it down. I do have it now in my possession in the file.
Okay.
Judge, may I make a record, please?
Oh, sure.
Okay.
Just 1 second. Court is calling 2023 CR 0787 State of Texas versus John Albert Sanchez. Can I have parties announced for the record for the state?
Honor Ochoa and Nelson.
Defense.
Andrew Del Cueto from Mr. Sanchez.
And are you Mr. Sanchez?
Yes, ma'am.
All right. And so, yes, defense, you wanted to make a record.
Yes, Judge, and if I hand you stuff, do I go?
Oh, you can just put it there and they'll give it to me.
Perfect, okay. Judge, the pivotal decision in this case is Watkins, right, which was decided. On
Okay, let
March.
me ask you this before you start. What are you going to be asking for?
Judge, I'm gonna say we're being denied a speedy trial,
Okay,
and I'm gonna perfect the record for it.
okay, no, that's what I wanted to know because
Yeah,
you're
I'm
presenting
sorry,
case
Judge. I
law.
apologize, yes.
Everyone, please whisper. Yes.
So anyway, this is a case decided by the Court of Criminal Appeals in 2021, March 3rd, 2021, that basically defined what is material. A material is basically anything that could make a difference in the case. I've handed that to the state and I've handed one to the copy. Subsequent to this, the state of Texas, through its prosecution guide, you were a prosecutor, you got this magazine every month, even wrote on it what the obligations of the state are pursuant to Watkins.
All right, they never gave me that magazine, by the way.
Okay,
I just did research on my own.
well, and then you did research on your own. But this article was published, the May and June article of 2021, the meaning of material in Watkins v. State. And it was done by the Texas District and County Attorneys Association, their appellate guru. And I'd like to introduce that as exhibit number 1. I'm handing a copy to Mr. Ochoa. Shortly after Watkins, there was a case called Hallman. And that was decided the next month. And in the Hallman case, and that side is 620 Southwest 3rd, 931. It said, we now vacate the judgment of the Court of Appeals and remand the case for further consideration disposition in consideration of Watkins. So they basically doubled down and they said, look, we didn't make a mistake in Watkins. This is good case law. I'd like to present that to the court. I give a copy to Ms. Ochoa from the state. And then after that, the same court that decided Watkins at the lower level, which was the Waco court, right? The very liberal Waco court, came out with the decision in Heath. And if you remember, Heath is about 911 calls not being handed over 6 days before trial, and the judge excluded it. And that is now up to the Court of County, it's up to the Court of Appeals, the Criminal Court of Appeals. Oral argument has already been done on it, but this is a lower court decision. And the side is 642 Southwest 3rd, 591. And I'm handing that case to the court and one to Ms. Ochoa. So, according to the CCA, our obligation is to request materials. So on July the 7th of 2022, which is over a year ago, and I'd like to introduce this as Defense Exhibit 2, we requested it. We requested non-scientific evidence. And we labeled it 1 hyphen request for non-scientific discovery pursuant to 3914. That is Exhibit 2. It's also in the court's file. I'm handing that to the prosecutor. Then, because there's cell phone dumps and the like, we also did a request for scientific evidence on July the 7th of 2022, labeled 2 hyphen request for scientific discovery pursuant to the United States Constitution, the Texas Constitution, the Texas Rules of Criminal Procedure 3914, and the Texas Rules of Evidence, the Texas Disciplinary Rules of Professional Conduct 304 and 309. And I'm labeling that as exhibit number 3 and handing a copy to the state. Then on February the 15th of 2023, because we kept coming to court and you're very direct and you're like, get your stuff done, guys. So on February the 15th of 2023, and I'll label this as Defense Exhibit number 4, we send an email telling Brittany Mitchell, and I know that Brittany Mitchell's not before us, it's Miss Ochoa, please, pretty please give us our discovery. That's Defendant's Exhibit number 4. I'm handing a copy to the state. And let me go back, this is out of order, I apologize. Also on 7/7 of 2022, we asked for Brady material. We asked for it in 2 ways. We asked for it specifically under Brady v. Maryland, but remember, there's an issue with materiality on Brady. And the only person that can tell us what is material to the point of a reversal is a Court of Criminal Appeals. But we also asked it under 3914H, which doesn't require materiality for it to be turned over. And I'll get back to what we think is Brady in a second. So I'll label that as Defense Exhibit number 5. That was filed on 7/7 of 2022. I'm handing that to the court and a copy to the state. Then on March the 17th of 2023, because we go to court again, we follow up with another email. And we say, look, pretty please, can you please give us the information that we've requested? And I'll label that as Defense Exhibit number 6. I'll give a copy to the court, and that correspondence was with Mr. Mitchell, and I'll give a copy to Ms. Ochoa. Then on May the 25th, we send another email saying, can you please, pretty please, comply with discovery? That's Defendant's Exhibit number 6. We send that one to Brittany Mitchell as well. I'll give a copy to the court and a copy to the state. Then on May 26th of 2026, we send another email saying, pretty please.
Just one moment, I'm sorry. Could somebody call the defense? All right, thank you. And Lance, if you'll let the state and the defense see that, please. All right, we're back on the record.
May I proceed, Judge?
Yes.
Thank you, Your Honor. We sent another email asking for discovery compliance on May the 26th, 2023. That's the defendant's exhibit number 7. I'm handing a copy to the court and a copy to the state. Then we file a copy on May the 25th, 2023, so the court will know that we're trying to take action. These emails have not been any type of filing with the court or court intervention, nor does there need to be. But we were concerned that the court thinks that maybe we were falling down on our job doing the request. So we send a letter and we file it with the court, and then it goes to the district attorney's office. That was filed on 5/26 of 2023. And that's defendant's exhibit number 8. I'm handing a copy to Ms. Ochoa. Then again, on 5/26 of 2023, we file another letter asking for specific discovery. That's defense exhibit number 9. I'm handing a copy to the court and a copy to the state. Then we file a motion for enforcement of Article 3914, and that was filed on 9/28 of 2023. That was when Judge Angelini was on the bench, and I'm labeling that as defense exhibit number 10. And when we approached on this case, Judge, in front of Judge Angelini, the representation of the prosecutor I'm sorry, we didn't approach at that time. We filed on 10/12 of 2023, defendant's second motion to enforce. I think Judge Angelini was on the bench at that time. That's exhibit number 11. I'm handing a copy to the court and a copy to the prosecutor. We followed up with an email on November 1st of 2023, asking for compliance directed at Brittany Mitchell. This is for a child safe video. Now, we didn't know that there was transition in the court with your prosecutors. We had no idea. We weren't trying to trick anybody. But it was basically to try to get access for our expert in Austin to view the video. And I don't know if she forwarded it to Ms. Ochoa. I'm not making that representation. I'm just saying that we sent it to the state. And that is defense exhibit number 12. I am giving a copy to the court, giving a copy to Ms. Ochoa. Then on November the 7th, 2023, we again asked for discovery. That is defense exhibit number 13. That is in an email. I'm giving a copy to the court and a copy to Ms. Ochoa. Also, we start corresponding with Ms. Ochoa, and she's brand new to your court. We realize that she has had no dealings with this case in the past. This will be our first appearance in front of Ms. Ochoa, but we sent her an email on, so I'm not blaming her at all, right? This is just the district attorney's office in general. On November the 10th of 2023, we sent her an email. And that's defense exhibit number 14. Asking for all the information we previously requested, which you ordered to be turned over. I'm handing a copy to the court and a copy to Ms. Ochoa. Then on the 13th day of October, we're in front of Judge Angelini, we're addressing our second motion to compel.
Mhm.
And the representation of the state off record was the judge has already addressed this. She gave us till the 14th to comply.
Yes.
I'm telling you, we will comply by the 14th. That was off the record.
Mhm.
I said, Judge, I just have to put some stuff on the record. Okay. So this is a transcript of that hearing.
So here's my question, and not to interrupt your argument, but interrupt your argument.
Sure, Judge.
So the deadline to comply is today. So do you have all of the records?
I believe so, Judge.
And have they been given to the defense?
I cannot say that with 100% certainty. I know I did direct the detective yesterday to tag those, all the documents, videos and reports from the Nicholas Ojeda case to share the JN with this case for Mr. Sanchez.
All right, does anybody want to call?
I can verify, because we looked at this morning, we don't have.
All right, no, so it's gonna happen today.
Yes, Judge.
So do you want to call your detective and tell them they either need to bring it to court, but it needs to be done Tuesday,
Yes, Judge.
and it needs to be done before 2 p.m.
Yes, Judge. I will call her right now.
All right, just 1 second in the hearing.
Sure.
If you want to pick up the phone and call them. And state in defense with regards to the question from the jury, I will give you guys a proposed supplemental, and you all can let me know if you agree with it or not.
Yes, Judge.
So just give me a moment. And Mr. Del Cueto, if you want to have a seat for a moment,
Yes,
let me have
Judge.
them call them, and then we'll complete this. All right, and while we're doing that, John Albert Garcia, is that a plea?
Yes.
All right, can I have the stamp, please? All right, and then after John Garcia, it will be Anthony White, Vicente Navarrete. All right, court is calling 2022 CR 6394, State of Texas versus John Albert Garcia. Can I have parties approach and announce for the record for the state?
Hank Wilkins to the state, Your Honor.
Defense.
Gerardo Flores from Mr. Garcia, Your Honor.
All right, good morning. You're on this side. And are you John Albert Garcia?
Yes, Judge.
All right, you seem confused. Is that you?
Yes, ma'am.
All right, counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, I'm showing you what's entitled application for probation. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're being charged with fraudulent use or possession of identifying information, 10 to 49 items as a second degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand I'm sorry, just 1 second. An email, just a second. All right, counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishments be assessed at 6 years in the prison. There's a $500 fine. The state recommends community supervision. And there's to be restitution to Julio Ladron de Guevara, Rolanda Hines, Kimberly Axel, David Maxey, Ray Neil McNeacher, David Bates, Eliz Landrone, G. Guevara, Daphne Jean McElwee, Jarrett Hall, Alyssa Castro, Dorothy Olson, Samantha Smith, Kayla Moser, Alma Gonzalez, and Jean Yestrone. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No motion.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 6 years. There'll be a TAP evaluation, 200 hours of community service restitution, and no contact with the complainants. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty, Judge.
State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
Any objections?
No objections.
All right, states, you may continue to confer. Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, I'm just asking the court to follow the recommendation with the government. In addition, Judge, he is a resident of Houston. Now I just wanted to request if his probation could be transferred to Harris County. Is it Harris County?
All right, why are you stealing? Why are you taking people's mail?
I just made mistakes and
No, that's not a mistake. Do you want the umbrella example so I can tell you what a mistake is? Here's a mistake. It's raining. I know it's going to rain. I come to court with my black umbrella. I'm sitting next to someone who has a black umbrella. People are coming into court. They're wet. I get up and I leave because I finished my business at the courthouse. I go outside the courthouse and I open the black umbrella and my initials are not there. I have mistakenly grabbed the wrong umbrella. You made a choice. Here's a choice. My mom didn't call me and tell me it was going to be raining. I wasn't expecting it. I didn't bring my umbrella. People coming to the courthouse wet. There's a person sitting next to me with an umbrella. I know it's not mine because I didn't bring one, but it's raining. I don't want to get wet. Chocolate melts in the rain. So I grab their umbrella and I go outside with it. Guess what? That's a choice. It's not a mistake. So you didn't make a mistake. So again, why are you stealing and taking other people's mail?
I made bad decisions.
Why are you making bad decisions? How old are you?
35.
All right, you're 35. We go back to the point of why are you breaking into people's mailboxes and taking what does not belong to you? There are people who receive their Social Security checks. There are people who get money once a month, and you're running around breaking into their mailbox and taking it. So again, why are you doing that?
Just, honestly, I don't have a really good enough answer. I made bad decisions, and I was doing dumb things, and I am really sorry for my actions. I don't have I don't have a reason to tell you that it's gonna make me look any better, because it's not it was not a good choice. I made bad decisions, and I messed up, and I know that, and I'm just trying to be accountable and just.
Who is Melissa Renee Carlson to you?
She was a person that, I think the person who was driving a car.
So you're in a car with somebody you don't know?
Well, I mean, I don't know her by that name. I know her by Momo, but we were just down here
Down here breaking into mailboxes?
Well, we're on a road trip, and then
a road trip to break into mailboxes?
That wasn't the initial thing that we did, Judge. We got here, and again, I made a bad decision.
All right, who is Matthew Bourgeois to you?
He was a guy that was in the car that's Momo's friend.
All right. Do you have any children?
No, ma'am, but my girlfriend does.
And how old is her child?
They're 3. Yeah, she has identical twins.
Okay. And was she on this road trip?
No, ma'am.
So when did you meet her?
10 years ago.
So how long have you been with her?
Off and on for 10 years.
All right. And what is her name?
Eka Muradashvili.
I'm sorry, what?
Eka, her first name. Last name, Muradashvili.
All right. Do you have a spelling for her first name?
It's EKA.
And how do you spell her last name?
Last name spelled MURADASH BILI.
Wait, DSH.
Yes, ma'am. BILI.
BILI.
Yes,
all
ma'am.
right, thank you.
You're welcome.
All right. How far did you go in school?
I went to the 10th grade, ma'am, but then I went and I got my GED.
Okay. All right, this is what the court is going to do. The court is going to sentence you to 6 years in the prison, suspended and probated for 6 years. There's a $500 fine that will be probated. There's to be no contact with the complainants listed in the indictment. There's to be no contact with Matthew, last name Bourgeois, or Melissa Carlson. There's to be restitution to the complainants listed in the indictment. $200 hours of community service restitution. And where did you say he wanted to be transferred to?
To Harris County.
Harris County.
All right, transferred to Harris County. ISF. The MRT. Is there an advanced theft course? Because obviously my theft course is not going to be enough for him. Don't break into mailboxes. Don't take mail that doesn't belong to you. If your name is not on the envelope, don't open it because it's not addressed for you. It's somebody else. If people don't give you permission to open their mail, then do not open it. Do you understand?
Yes, ma'am.
Some sort of theft course.
There's 1 and 2. 2 is advanced.
He needs a 2. All right, and there's to be no contact with Elka Marish Billy, regular reporting by Zoom or in person, the UA hotline, proof of employment within 30 days, no employment as a home health care provider or with minors, TAP evaluation in custody, and follow TAP recommendations. All right, probation, is there anything else it needs? All right, is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. I know you're wondering, why am I saying no contact with your girlfriend? It's because she doesn't need you in her life. Like if it's just adults, she can make her own decision, but she has 3-year-old twins. And you're not the type of person who should be in the 3-year-old twins' life. Do you understand?
Yes, ma'am.
All right, good luck to you. And let me see here. All right. Ooh. State and defense.
On the burden.
Yes, I'm going to print out several proposals. And if you all can just let me know which one you would like.
Yes. We pick that up? Yeah, that's not mine.
All right, could I see that was just printed out, please?
And I hope you put those on the right stack.
I know, I wouldn't want to mess up this organizational masterpiece. Looks like.
Oh, no,
it's
we're
gonna
good.
work.
So let me know if you have any objections to that. And then who's here on Anthony White? All right,
You want him to come up?
yes.
That's what I wrote.
Are you guys okay with that?
Okay with that, Judge.
State, are you okay with that?
Yeah, that's actually sort of what the state was gonna request.
All right, Deputy, could you have Mr. Dixon come out?
No, we don't need it.
Judge, we're okay, we're okay with that, Your Honor.
No, he has to be out for this to be read on the record.
Oh, all right.
All right. So if you guys have a seat, they're going to bring him out. Anthony White. All right, where are we on this case?
Hey, Judge.
Hello.
This is actually my first setting on it.
All right, and this was supposed to be recalled for November 28th.
Yeah, I'm not sure why it's on the docket. for
Yeah, I'm not
today.
sure either, but we can take care of it now.
Well, in speaking to Mr. Cavazos from the DA's office, I'm gonna provide him a USB drive this afternoon so he can download Discovery for me. We've been conferring about possible outcomes and we're working hopefully towards a resolution.
All right, Lance, on Anthony White, can you reset this for December? And it's to make sure you all have all your Discovery, but state on that day, you need to be prepared to tender an offer.
We will, Judge. December 11th.
All right, December 11th. Once you sign the reset form, you're excused.
Okay, thank you. Do you have a seat? So we'll sign a reset form. Okay, thank you, David.
Vicente Navarrete. All right, where are we on this case?
So Judge, the last setting, you appointed the PD to represent him for immigration purposes.
Yes.
Apparently the order did not make its way to the PD's office till this past Thursday.
Mhm.
Miss May is actually in the witness room. She's started the intake process to speed this along with my client. So-
All right, Lance, could you recall this for December as well? Yes. All right, we'll come back for December 11th for an update on the Padilla letter,
Thank you, Judge. May I be excused?
after he signs the reset form.
Yes.
All right, we're gonna go on the record. In 2022 CR 9807, State of Texas versus Vernon Dixon, the court has received the following question from the jurors. Do we all have to agree on A or B in count one? Have both parties had a chance to review the question, state?
Yes, Your Honor.
Defense?
Yes, Your Honor, we have.
And the court is proposing the following supplemental charge. Members of the jury, with reference to your inquiry as instructed in the court's charge, you're instructed that your verdict on count one must be unanimous. All 12 of you must agree beyond a reasonable doubt that on or about the 31st day of March 2022 in Bexar County, Texas, Vernon Dixon either intentionally or knowingly caused the death of Avante Boyce by shooting Avante Boyce with a deadly weapon, namely a firearm, or Vernon Dixon with intent to cause serious bodily injury to Avante Boyce did commit an act clearly dangerous to human life that caused the death of Avante Boyce by shooting Avante Boyce with a deadly weapon, namely a firearm. Please continue your deliberations. Any objection, state?
No, Your Honor.
Defense?
No, Your Honor.
Any objection to having the deputy take the supplemental charge back to the jurors, or would you like them to be brought out in the courtroom?
We have no objection to the deputy taking the supplemental charge to the jurors and back.
All right, thank you.
Thank you, Your Honor.
All right, that's done. Okay, these are done. Thank you. Lisa Marie Anderson. All right, who's the attorneys on Lisa Marie Anderson? All right, and Lisa Marie Anderson, come forward. Court is calling 2023 CR 7421, State of Texas versus Lisa Marie Anderson. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Lisa Marie Anderson, or Elizabeth Pressel for Lisa Marie Anderson, Judge.
Okay,
Sorry.
that's okay. And are you Miss Anderson?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Ms. Anderson, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it? Going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of driving while intoxicated, third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Anderson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $500 fine. State recommends community supervision, ignition interlock for half the term. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Next, I'm showing you outside the agreement, off the record. Deputy Mejia, could you order lunch for them? Okay, thank you. We're back on the record. So outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 120 hours of community service restitution, and the state is unopposed to house arrest for your 10 days in the Bexar County Jail, DWI intervention, and VIP. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Your Honor, I offer State's Exhibit 1 in the attachments.
No objection.
Going to show you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Oh, and state, you may continue to confer. Did you understand that the state would be presenting evidence in the form of witnesses' statements, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
And Judge, when given the opportunity, I would like to address the TAP evaluation and the 10-day house arrest.
Yes. All right, after reviewing State's Exhibits 1 and attachments, the court would find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Since the date of this offense, my client has been lost her job, but was reemployed shortly after the arrest date at Toyota. She's currently residing in New Braunfels in Comal County. So we would request, Judge, if it's appropriate and you do sentence her to probation, that as long as she's reporting by Zoom, she's not requesting a transfer. But if she is required to report in person, that she could be transferred to Comal County. Additionally, in regards to the TAP evaluation, we would request that she be allowed to remain on bond while pending that TAP evaluation. She has appeared to court on time at all times, has been compliant with any court required pretrial services. She's completed 2 pretrial required DWI classes. And additionally, Judge, she has sought out her own sober support. In New Braunfels, she was not able to find anything in person except for a Spanish class, and she doesn't speak Spanish. And so she has now sought out a online sober support group. She hasn't started attending meetings yet, but is going to start. And then additionally, Judge, in regards to the house arrest, we would request that the jail sanction be allowed to occur on a 10-day electronic monitoring link, and that she be allowed to attend work. It is vital to her success on probation that she remains employed with Toyota, especially now that she will have a felony conviction if the judge finds it acceptable to follow the plea agreement. And it'll be very difficult for her to find another job, which she's aware of. She's aware that she put herself in this situation and she's accepting full responsibility by her plea of guilty. And so again, she would request that she be allowed to do that 10-day jail sanction with house arrest, but be allowed to still attend work at Toyota.
All right, based upon the conditions at the jail, you can either do 10 days at the Bexar County Jail or either will be 30 days house arrest. Which would you prefer?
Judge, would she be allowed to attend work for those 30 days?
Yes.
Of course, yes.
I know some people choose jail.
Well, if I could, I have to work. If
Mhm.
we get points and if there's so many points. Yes, ma'am. I'm sorry.
No problem. All right. Who do you live with?
Myself.
Okay. This is what the court is going to do. The court is going to sentence you to 5 years in the prison, suspended and probated for 5 years. There's a $500 fine that will be probated, transferred to Comal County. TAP evaluation that will be done out of custody. Follow the TAP recommendations. If TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. If they recommend outpatient treatment, we're still going to start with intensive outpatient treatment. There's to be 90 sober meetings in 90 days, ignition interlock for half the term, 120 hours of community service restitution. You can work those hours or either you can pay it off at $7.25 per hour to the San Antonio Food Bank. Proof of employment within 30 days, no employment as a home health care provider or with minors, DWI intervention, VIP live, 2 years driver's license suspension, regular reporting by Zoom or in person, regular UAs, 30 days GPS partial for work only, and waive or defer fees, and DWI education. Probation, is there anything else she needs?
We still need to finish completing the data sheet. I think she's about halfway done, but she'll complete that before she leaves the courtroom today.
And excuse me, I think they gave you my original. So if I can have that one back and I'll give you this one. Probation, anything else she needs? All right, thank you. Is there anything else you need from the court in order to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Driving while intoxicated, not a good thing. Nobody ever goes out to a restaurant or to a friend's house and say, gee, let me drink so I can drive while intoxicated. What ends up happening, you become intoxicated and then you go drive because you're not thinking. Anybody can be killed when somebody is out driving. And what I've discovered, the people who usually are fine is the person who's driving intoxicated. Everybody else gets multiple injuries or everybody else ends up dying. So you appear to be one of those people who cannot drink alcohol at all. And while you're on probation, you're not allowed to drink alcohol at all. Do you understand?
Yes, ma'am.
All right. Yes.
Judge, if we could go back on the record, we do
Sure.
have a request in regards to the super fine. Because of the suspension and the conviction, there would be a super fine imposed by the Department of Public Safety. We are court appointed, so we request a continued finding of indigency from Ms. Anderson so that the super fine would not be imposed.
You'd have to have a hearing on that, and she'll need to bring documentation of her salary for me to do that.
Okay.
All right. All right, Luis, just remain in the courtroom. Probation will go over conditions with you. All right, Luis Hernandez. Who's here on Luis Hernandez? All right, come forward, Luis Miguel Hernandez.
He's in the hallway in shorts. Would you like him in here?
Yes.
Let me grab him.
And then after that, it's going to be the plea on Damon Terrell, the sentencing. Is the attorney here for Damon Terrell? Yes.
David Thomas.
Thomas, all right.
I have an interview at 1:30 for this. My client, we're first setting, we've discussed the offer and we'd asked for a reset. We've got.
Okay, I need to take up this first. Thank you.
I just wanted to see how the court's.
I appreciate it. Have you had them to pull the file?
Yes. I believe.
Okay. And counsel, you're on this side. All right, where are we on this case?
Your Honor, this case was set yesterday. When I checked in, the defendant had not. Lance recalled it for today. I've confirmed with the state. They're tendering an offer. We just want asking for 2 weeks to consider it and obviously to get Mr. Hernandez dressed appropriately to take that plea in the court.
All right, Lance, could we recall this in 2 weeks for a plea? It's Luis Miguel Hernandez. All right, November 27th.
We'll be here, Your Honor. Thank you very much.
All right, once you sign the reset form, you're excused. That's done. Mark Anthony Costa.
Because we confirmed the state, they've made us an offer. I made a counter offer, but this time we're at an impasse.
All right, let me have him come up. All right. So you have all the discovery?
I do, Your Honor.
How old are you?
37.
All right, Lance, if you could recall this back for a plea deadline date in 2 weeks. And it's Mark Anthony Costa. All right, November 28th. Once you sign the reset form, you are excused.
Thank you, Judge.
You're welcome. Antonio Barrientos,
Chief President of Council, Your Honor.
come forward. Mr. Barrientos. Who's the state on Antonio Barrientos? All right, where are we on discovery?
Judge, the state has given us the discovery that they have. My client has told me that there is a ring video that the brother has knowledge of. We're trying to get that, and we'd ask for a short reset that'll show the entire incident.
All right, are you able to have that in 2 weeks?
I think we should know if it exists and have it in 2 weeks or not, because it's the neighbors.
All right, Lance, if you can recall this for 2 weeks, it's on Barrientos. All right, November 28th, we'll be back and they'll have the ring video if it exists. All right, thank you.
You guys coming through.
Yes.
Yes, Judge. Do you still have the Terrence Bowie files?
Yes.
He's not here. They took him down because he's gonna satellite, but I did already meet with the prosecutors. They've made an offer. I haven't, I just learned of these cases yesterday and haven't even signed on, to be honest, which I'll do this afternoon.
All right, you'll need to inform your client, you understand?
I will.
All right, Lance, on Bowie, can I have a 30-day reset? And it's just a regular reset.
Very good.
All right, December 14th.
Thank you.
Does your client need the reset form or no?
No.
All right.
I'll have him here. Thank you.
All right, thank you. Hello.
Hello, Judge. On the sentencing for John Garcia.
Uh-huh.
We did ISF. What is that, local?
State. Well, it's for cognitive. So if there's a local one that's cognitive, then we'll do that one. Whichever is the quickest one for him to go to.
Right, okay.
All right, thank you. And Deputy Mejia, as soon as the food is here, we'll take our lunch break. Damon Thomas.
Ready, Judge.
Court is calling 2023 CR 3239, State of Texas versus Damon Thomas. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
David A. Garcia, attorney for the defendant, Judge.
All right, we are here for sentencing. He entered a plea of no contest to count 2 on October 5th. The court found there was sufficient evidence to find him guilty. According to the plea bargain agreement, the state is silent on his application and punishment is to be assessed at 10 years in the prison. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right, any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
All right, defense, do you have any witnesses?
We do, Judge. We have one witness, Eric Nuncio.
All right, they come forward. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Eric Nuncio.
I'm sorry, the last name?
Nuncio.
Could you spell that, please?
Nuncio.
All right, thank you. Defense.
Now, Eric, how do you know Damon here today?
I've known him just from the neighbor. I've known him like around my neighborhood. I've known him for about 5 years.
And what do y'all do together? Well,
So-
first of all, what do you do?
So I own a youth basketball organization here in town with over about 125 kids in my program. So pretty much what he does is he does a lot of the strength and conditioning parts of my program. He does a lot of the mentoring with the kids that are from the inner city. So that's pretty much what he's involved with.
And what's the name of your organization?
Lion Life Basketball.
So when you say he works with the kids doing strength training, what exactly does that mean?
So pretty much, I played basketball my whole life, so I do a lot of the skill training and stuff, and more of the intense. He's good with motivating kids and getting them to go. So I feel like that is a good way of them getting pushing them, and a lot of the kids that are not as skilled or not as in shape. He deals with a lot of those kids that are kind of starting off.
And what's the age group of these kids we're talking about?
So we start at 5 years old, from kindergarten, and we end all the way to 18 years old, senior high school.
And are all of the kids that you're involved with playing sports in their schools, or are there some that just come to participate?
Well, a lot of the kids in my program, I offer for ones that don't make their basketball teams, like the ones that are less fortunate. A lot of the people in this city want a lot of the kids that are, talented, and my focus and our focus is the ones that are, kind of forgotten. Yeah.
And is the goal of your organization not only to help these kids physically, but emotionally to deal with life?
Yes, and that's a lot of the reasons why I like to deal with a lot of those kids, the ones that get cut, they get, they get discouraged, and those are a lot of the kids that you see around here doing things they shouldn't be doing at the ages of 6th grade, 7th grade. So those are the ones that we kind of reach out to the most. So I think it's a very good, opportunity for a lot of kids that are, kind of go under the radar or kind of feel like they're left out.
So what you're trying to say is basically you keep them off the streets, you keep them busy doing something positive for their body, for their mind, for society?
Yes, sir.
Have you seen good results over the years that you've been working on this?
We since we started in 2013, we put 37 kids in college, and countless kids play around the city.
Do any of those kids ever return to try to help out?
So
with the program?
I have about 3 of my coaches that are former athletes in the program.
And how often per month does Damon work within your program?
He was there. He was there pretty much every day. Like I said, I have a group that's kind of sticks to themselves, and he has a little group that he kind of sticks with, that he was sticking with at the time before he was
arrested.
Yes, sir.
And this group, do you see positive results from his work with the kids?
Well, some of them are new. A lot of kids I have now are new. But yeah, I think any kid that gets a little hands-on or has a type of attention to him is gonna see some type of you're gonna see some type of success in that child.
Would you say that both you and Damon are sort of filling in for absentee parents?
I mean, I would say we're there to support some kids. I'm not. One thing I do say is I'm not a parent. I'm a role model.
a lot of these kids that do need help, I do say that we do, we are there for a lot of kids that are less fortunate. We are lucky enough to have a lot of the kids that have a great parents around them, which the parents are very good with both of us. So that's a great thing as well. But the ones that don't have that type of guidance, we're always there for them. For sure.
Would you say that Damon is an asset to your program?
100%.
Now, you understand why Damon's here in front of the judge, right?
I've heard, yes, I've heard that.
And in spite of this, he's got an application to the judge, hoping that she will give him probation. So if she were to give him probation, would you still allow Damon, knowing that he's here on a drug charge, a serious drug charge, would you still allow him to work with the kids?
Yes, Damon's never showed that type of side ever to any of myself or my family or any of the families around. So I don't feel him at risk of anything. I think if anything, when he's around, I think a lot of parents feel safe. He's a protector, sort of kind of person. So I feel like, it's total opposite. I think he's a very good asset, 100%.
Are you asking this judge to show him some leniency and give him that probation?
Please. I think he's learned his lesson being here long enough, and I know a lot of the kids miss him.
He's been sitting in jail for almost 10 months, right?
Yes, sir.
Almost 11. I'll tender the witness, Judge.
All right, any questions?
No questions, Your Honor.
All right, thank you so much for coming out and thank you for what you do in the community.
Thank you so much.
Judge, my last witness would be Damon Thomas if he decides he wants to speak to the court.
All right, do you want to speak to the court?
Yes, ma'am.
All right, just so you know, before you speak to me, I've already read the police reports and I've read the PSI report. And I've read what you stated in the police report and I've read what you stated in the PSI report. So do you still wish to speak to me?
Yes.
All right, you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Damon Thomas.
All right, defense.
So, Damon, what exactly do you want to tell the judge?
Well, I just would like to tell the judge that I believe that I deserve probation. I've never been on probation. And if I was to mess up, I got to do a 360 and come stand right back in front of you again. And I don't believe you'll have to worry about that. You know what I'm saying? I think I learned my lesson and I need to do what I need to do because I got a lot of stuff going on. And my child's mother, she was diagnosed with stage 4 cancer. So I got a lot going on right now.
Damon, do you think if the judge gives you probation, you can get a job that will continue to help you support not only yourself, but your family?
Yes, sir.
Will you continue to work with Eric Nuncio and help the kids in the community?
Yes, sir.
Will you follow each and every requirement as part of the probation or that the judge requires so that you make sure you don't make any mistakes?
Each and every, from the beginning to the end.
And Damon, you understand that the judge has looked at your record. It's a horrible record, isn't it?
Yes.
You made a lot of
to be proud of.
You made a lot of mistakes.
Yes, sir.
What can you tell the judge that is different in you now than all those years of you making mistakes and committing crimes and or going to prison?
Well, I can say you live and you learn, and as you get older, you become wiser and you understand that in and out of incarceration is the wrong way to go, you know, because you got, like to say, I got these kids watching me. I'm like in a microscope, you know what I'm saying? So that doesn't look good on me as a person, or a human, especially with dealing with these kids in this type of situation.
You understand you put yourself in a bad situation when you were at that house. It wasn't your house, but you were at a house that had a lot of drugs at it, right?
Yes.
And you understand that was your mistake.
Yes.
What's going to be different that you don't put yourself in these kinds of mistakes in the future?
I'm gonna stay out of the projects. I'm gonna stay out of the projects. Cause that's the wrong place to be. Cause at the end of the day, with this situation, it was kind of like being in the wrong place at the wrong time, and everything kind of really fell back on me. So I know that I got to move differently in the world.
And you're asking the judge for this one last chance for probation.
Yes, sir. I'm asking Miss Boyd to give me another chance at society, because again, if I fail, I'll be standing right in front of you again. And you can do what you gotta do to me.
No further questions, Judge. I'll turn to the witness.
Any questions?
No question.
All right, so I'm reading the police report. And in the police report, it says that you admitted to owning the clothes and shoes found in the apartment closet.
No, ma'am.
And then it says that you admitted to the illegal narcotics being yours.
No, ma'am.
Okay.
I think what happened is there's a video, Judge,
Mhm.
where he's being interviewed by the detective that executed a search warrant at this location that Damon didn't live at. He was in a relationship with a woman that lived at the location. And when they executed the search warrant, Damon had been talking to one of the people at the house, and he was holding the drugs that he was asking this guy about. When they rushed in the door, Damon got up and ran, and he ran holding the drugs. And so the officer or detective that was questioning him on video asked him about that, and he admitted that he was holding it. And that's where they take it that he admitted.
Okay.
So he still was in the wrong place at the wrong time. He still was putting himself in a position where he should not have been judged. He should have known better. He knows that. He's made a lot of mistakes, but he's an older man now. He finally had things settled down, working with this youth group, and he's hoping that you'll give him that chance. He'll stay away from everyone in that neighborhood. He'll stay away from that woman. He'll do whatever you require to prove himself, Judge.
Yes, ma'am.
All right, so I've read everything. I've internalized everything that was said. I'm not going to grant your application. I'm going to find you guilty. I'll sentence you to 5 years in the prison, give you credit for any time served. Taking consideration 7004737177551, and I'll ask for the therapeutic community. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, and actually I gave you something better than what you pled for. You do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to the attorney. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. I know 5 years is a lot of time. Anytime you do a day in custody is a lot of time. You're going to have to make better use of your time. And when you are released from prison, you need to make sure that you stay on the path to be around people who are doing the right things. You understand?
Yes, ma'am.
All right, good luck to you, Mr. Thomas.
What do you say to the judge?
Thank you.
Oh,
Thank you,
you're
Judge.
welcome.
Good luck.
Jasmine Hunt.
Yes, Your Honor.
All right. Where are we on this case?
This is our first appearance, post indictment, Your Honor. I spoke with ADA Daniel, and I believe they need a little time to reach out to the victim.
Judge, yeah, we were just gonna ask for 1 second just to reach out to the victim.
All
That's
right.
reasonable under circumstances, Your Honor.
Lance, can you give me a 30-day reset for this, but put it in December? And it's Jasmine Hunt.
Can I start on vacation that day, which is on file, Your Honor?
All right, just 1 moment.
14th.
Can we do it? Yes, December 11th. All right, we'll see you back on December 11th.
Yes, Your Honor.
Thank you, Judge.
You're welcome. Asias Guerra.
Here, Your Honor. Hold up.
All right, where are we on this case?
Who are you addressing, Your Honor?
Oh, both.
Your Honor, if I may,
Yes.
this is a second setting. I was here on a first setting and, there was a discrepancy. Did you miss court, came in and the judge reinstated you. So that was our first setting and I spoke to the prosecutor. I have started to receive discovery, but I'm reaching out to Cuero, where the police report states that everything is based off of a police report out of Cuero, and I'm getting no response from the city of Cuero or the county of Cuero. I'm talking with the state and I'm just trying to get more discovery. I don't think they're ready to tender an offer before I see all the facts.
All right, so where's state, do you have access to what he's saying out of Cuero?
No, Judge, but I can ask our investigator to call them and ask for the police report. Judge, but if we can get some more time for like a discovery.
Okay, and where is Cuero?
Is that about?
No. Where's Cuero?
About 2 hours from here.
2 hours from here?
Yes.
Okay,
77 zip code, 77954.
all right. I'm still learning the counties in Texas. Hey, if you ask me about a parish in Louisiana, I'll tell you where it is though. All right, Lance, could we set this for discovery in 1 month? December 18th for discovery, and if y'all can check on this out of county report.
I'll provide everything to the state that I've requested.
All right, once he signs it, you're all excused the reset form.
Thank you, Your Honor.
You're welcome. Larry Nunez.
No, Judge.
Hello. All right, where are we on this case?
Yes, Judge, this is our first setting in this case, Judge. We have conferred, we were lacking some discovery, some MPDs. We did.
What discovery is pending?
Oh, no, Judge, they were able to copy them for us today on a CD and I have it now.
All right, and there's no standing orders needed in this case?
I don't believe there's you haven't got a blood discovery. No, Judge.
All right, Lance, if you recall this for a month. And that's just to make sure you have all of the discovery.
Yes, ma'am.
December 14th.
14.
All right, December 14th.
It would be Fusion.
Thank you.
I appreciate it, Judge.
You're welcome. Kimberly Dixon. And probation, this is an application for deferred adjudication. Court is calling 2023 CR 8805, State of Texas versus Kimberly Dixon. Can I have parties announced for the record for the state?
Is that done for the state?
Defense?
Christine McDonald substituting for Renee Munoz for the defendant, Judge.
All right, and are you Kimberly Dixon?
Yes, ma'am.
All right, do you have any objections to this attorney standing in?
No, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, we have, Judge.
Court will find that the state is in compliance with discovery. Ms. Dixon, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
All right, if we could go off the record for a moment, please. If the attorneys could come around. No.
Pardon me.
You have to bring it to the court. It's full range of punishment. So you could put his recommendation if you want the deferred adjudication.
Just another thing I forgot, the beginning of this is Ryan. Ryan, put this in last name. I think it's on.
Oh, that's taking on something too.
Okay, and then we'll take a recess.
It's Ember.
30
Yeah.
seconds, Your Honor.
That's right.
Oh, no problem.
RYA.
Diana. After this, we're going to take our recess. Okay. Yes, after this one, just this plea. All right, everyone, after this plea, the court is going to take its lunch break and we will be back at 1:20.
Can we go eat right now?
Sure.
All right, we'll obviously have our cell phones, you don't need to reach us.
Okay,
Thank you very much.
you're welcome.
Went ahead and just wrote it.
All right.
I'm working on it.
Okay, sure, but you should put it down here. That's okay.
Give up on me, Josh.
Oh, no. Let me just tell you, everything is a learning process, and believe it or not, even though I had a lot of experience when I went to the DA's office, I still had to learn the computer system and the paperwork. So you just put it down. Sure, no problem. All right, we're back on the record. I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right, what you're charged with in the indictment is injury to the disabled, bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
All right, off the record for a moment. Can you make sure that they're not leaving? Okay. All right, we're back on the record. Did you understand that the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Dixon, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney?
Yes, Your
Did
Honor.
you understand it?
Yes, Your Honor.
According to the plea, state recommends deferred adjudication. They're taking in consideration County Court Cause number 712858. There's an affirmative finding of family violence. There's to be no contact with Ryan Embry. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of your plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you what's entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
No, Your Honor.
Outside the plea, the state is recommending that your deferred adjudication be for a term of 3 years. Did you understand that that was a state's recommendation and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State, any evidence?
Yes, Your Honor. State offers states one and attachments.
No objection, Your Honor.
State, have you had contact with the complainant?
We have, Your Honor.
All right. And the complainant is aware of this plea?
The complainant is not cooperative with her officer.
All right, thank you. Ms. Dixon, I'm going to show you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will present evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're just respectfully requesting that we follow the plea bargain.
All right, who's the toddler?
My son,
Where's your son now?
he's with his older sister, Raylan Stowe.
And how old is the,
She's 21.
and the complainant, was that your boyfriend?
Fiance, yes, ma'am.
How long had you known him?
22 years.
So is there a mental health issue here, or she's just a violent person?
Your Honor, I am filling in for Mr. Munoz, Judge, for this plea.
All right, do you have any mental health
I'm
issues?
bipolar.
How far did you go in school?
Vocational medical office.
All right, when's the last time you had employment?
It was last year, 2022, it was the April.
Have you been in jail since April 2022?
No, ma'am.
So why do you not have employment?
It's just been difficult with my son because he's autistic.
Mhm.
Trying to find part-time work for his hours of school and stuff like that. So it was
All right, is Child Protective Services involved?
yes, ma'am.
All right, and do you have an attorney on the CPS side?
No, ma'am.
Is this
She's
a,
been working with my daughter while I've been in here. I've seen her a couple of times.
all right, what's your daughter's name?
Raylan Stowe,
Spell the first name.
RAE, capital LYNN.
And what's her last name?
Stell, STELL.
And what's your son's name?
Miles, MILES. Rich, RICH.
Is that the only child you have other than the 21-year-old?
No,
who's
I
watching?
have 3 other grown children.
Okay.
But he's the youngest.
All right. This is what the court will do. The court will sentence you to 3 years deferred adjudication. There should be CPS compliance. There should be no contact with Raylan Stale. There should be no contact with Miles Rich. And counsel, if CPS decides that she's doing her service plan and they want her to have contact, you have to come back to the court and request that.
Yes, Your Honor. Your Honor, may I ask my client a question?
Sure.
So your safety plan in place right now? Okay, are they allowing me any kind of visitation?
They said supervise. As soon as I got out, I was supposed to call her. She could UA and then she's talking about supervise visitation. But she was just waiting for me to get out.
Your Honor, may I offer some information to the court? Your Honor, according to my client, there is a safety plan in place which would allow her supervised custody, Judge, and I would just respectfully request if you would consider contact mirroring the CPS safety plan, Judge.
All right, if the Child Protective Services worker wants to come in and speak to the court, then the court would consider that at that time.
Yes, Your Honor.
So no contact with Ryan Christian Emery, regular reporting by Zoom or in person. I'm gonna want a MIC evaluation, TAP evaluation, follow recommendations of TAP, proof of employment within 30 days of release. There should be no employment as a home health care provider or with minors. I'm gonna want field visits 1 time per month until further notice. Regular and random UAs. 200 hours of community service restitution. I'm going to ask for parenting classes. Once that's completed, the court will deem the 200 hours of community service restitution satisfied. Take in consideration County Court cause number 712-858. There's an affirmative finding of family violence. Probation, is there anything else she needs? Is there anything else you need from the court? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. Off the record, here on out, everything that you do, you need to ask yourself 2 questions. Is what I'm doing, could it potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. And you have to make sure that you're in compliance with Child Protective Services, because that's a part of the conditions of your probation. You understand?
Yes, Your Honor.
All right, good luck to you.